Yeah, that's better.
She's gone.
Oh, she said Carol left?
Carol McCoskey.
Yeah.
She's
Oh,
city attorney.
Now, you didn't tell me about Carol, though. I didn't realize
Couple
that.
months,
Wow.
but she's city of
So did you.
City of Falls chair.
That's what you do in retirement. You get it bigger and better.
Appeal. Oh, these are not in order.
I didn't touch them yet. Sorry.
Yeah, that's okay. I want to make sure I'm not missing any. Oh yeah, I figured we'd have a lot on that one. 6. I think I've got them all. 1 is the first one. 6. Good evening, everyone. My name is Cecilia Espinoza. I'm the chair of the Board of Zoning Appeals, and we welcome you tonight to the monthly meeting of the Arlington Board of Zoning Appeals. We're also known as the BZA, so if you hear me speaking this evening, you might hear us go between the terms Board, BZA, and Board of Zoning Appeals. In addition, tonight with me, the board is made up of 5 citizens who are appointed by the Circuit Court. Our vice chair is not present this evening, but seated with me tonight are, to my right, to my left, your right, Judy Freshman. To my right, your left, Charles Smith and Terry Russell. Also present are our professional staff, including Deputy Zoning Administrator Andrew Noxon, who serves as the Secretary to the Board of Zoning Appeal, Norma Cozart, the Zoning Administrator, Clifton Hogan, Assistant to the Zoning Administrator, and Cheryl Williams, the Zoning Technician. In addition, you'll see on the front up here 2 county personnel, or I guess a court reporter and a county attorney who are with us for the first case this evening. Again, we thank you for being here, and we extend a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in silent mode, or any other mobile devices you might have. On the front table, you'll find copies of the staff report for each case before us this evening. I recommend that if you've not yet seen that report for your case, that you get a copy of it and review it before your case is called. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the county board. The board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1 and 2 family lots where there is no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance. And 3, we can decide appeals of the decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meet conditions and that the use permit will not, first, adversely affect the health or safety of persons residing in the neighborhood, second, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and third, will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To make this assessment, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint size and placement are similar to the structures on the property surrounding the lot in question, and whether the modification will help preserve natural landform, historical features, and/or significant trees and foliage. When granting variances, the board must determine that the strict application of the ordinance would produce undue hardship, that the hardship is not generally shared by other properties in the same zoning district, and that the authorization of the variance will not be of substantial detriment to adjacent property, and that the character of the district will not be changed by the granting of the variance. A Virginia Supreme Court ruling requires that a variance cannot be granted unless the effect of the zoning ordinance, as applied to the piece of property under consideration, would, in the absence of a variance, interfere with all reasonable beneficial uses of the property taken as a whole. When deciding appeals of the zoning administrator, the board must determine if the administrator acted correctly. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, board members will ask any questions of the staff that they may have. Next, applicants or their representatives will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, and I have several of them here, so we'll have several people tonight, which is available on the table in the front of the room. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We have deemed the following time limits for speakers to be sufficient. 5 minutes for applicants for use permits and variances. For use permits and variances, we've deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient. Ms. Williams will note that by the lights on the podium, so when you see them, they'll start with green, go to yellow, and then turn to red. When they turn to red, we'd ask you to stop speaking, and we'll move to the next person. After the board has gathered all the information they need and discussed this case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. This evening, we also have an appeal from a purported decision of the zoning administrator. It was actually an action by a deputy zoning administrator that has been remanded to us from the circuit court. The time limits for those is a little longer, Mr. Knox, and I don't have that in this 20 minutes, isn't it?
Got 20 minutes for the actual appellant, 2 minutes for anybody speaking against.
Okay. So our first case, which is that appeal, is a 20-minute case. It'll be a little longer than the rest of the cases that we'll be hearing this evening. But I wanted to let you all know that because I just told you we're going to have these short time periods, and we're going to start with a case that'll be longer than that. Anything else, Mr. Knoxon? If not, we're ready to turn over to our first case.
Thank you very much, and good evening, everybody. Our first case tonight, as Ms. Espinosa said, is a returning appeal.
Mr. Knoxon, before we move, I see we have carryovers. Does that mean they're being carried over again, or?
We've heard them before.
Okay, they're not being asked to be deferred again.
No,
Okay,
not this time. They're
I
going
have
to be heard.
speakers on those cases, and I just want to clarify that we're going to be dealing with that since it's at the end of the agenda, and I wouldn't want people to stay for the whole agenda if it's not going to continue, but it will. Okay, thank you.
Okay, our first case tonight is V-10681-12-APP-2. This is an appeal by Deborah Colt of the Assistant Deputy Zoning Administrator's oral statement on the basis for approval, the building permit number B11038180. This is in the R10 zoning district on the premises known as 3401 North Piedmont Street.
And the issue in this case is that the circuit court ordered the BZA to hold a hearing and decide several issues related to the appeal of the Deputy Zoning Administrator's oral statement of the basis of the approval of the building permit B11038180. The recommendation is that the Board of Zoning Appeals make the findings in the attached resolution and determine that Ms. Colt was not aggrieved by her April 25, 2012 conversation with the Deputy Zoning Administrator, that the conversation between the Deputy Zoning Administrator and Ms. Colt was not a decision determination, requirement, or order under the Code of Virginia, and that the building permit number B11031080 issued on January 4th, 2012 was properly issued. Do we need to say anything further for the record, Mr. Noxon, or do we proceed at that point?
Ma'am.
Okay, we can proceed, and I believe we begin with the applicant, and that person is represented by Mr. Lawson.
Thank you, Madam Chairman. I'm going to speak for a few minutes, and then Ms. Colt is also going to share her story with you.
Okay, Mr. Lawson, just for the record, as you know, you are the representative for Ms. Colt, 1100 North Ohio Street, Arlington, Virginia, 22205. Is that correct?
Yes, ma'am.
All right, thank you, Mr. Lawson.
Thank you. A number of people have asked why I'm doing this, and the reason I'm doing this, and I'm helping Ms. Colt, and this seems like a minor thing, but it's an important concept, and I think it involves the legal concept of due process. And what has happened, there's been a lot that's happened since we were last here. Went to the circuit court. The circuit court ordered this body to go ahead and render a decision. The county appealed that to the Supreme Court, and the Supreme Court declined to hear it. In addition, there was an amendment to the ordinance, which also impacts what we're doing here today. The amendment of the ordinance leaves the issue being the steps. So the only issue before you all tonight is our allegation that the steps are too close. We're not talking about the deck. That's gone away due to the amendment to the ordinance. I want to hand out two things, two surveys. One is the one that the Kleins had, and then the other is one that Miss Colt got. The one that Miss Colt got is an actual survey as opposed to a house location survey that had the improvements shown on it. Entirely different animals. And I have more than 5 copies now here. Before I get into the merits, I'd like to say for the record that we have no quarrel with the Kleins. They're kind of caught up in the way the county handled this. And I have no quarrel with the zoning staff. We work together all the time, and we get along very well. But I just think that this zoning complaint was just not handled correctly, and that's why we're here. First thing I want to talk about, there's a lot of talk about 15.2, 2311C. And in the staff report, the conclusion is made that disposes of the issue. A building permit was issued, 60 days came and went into discussion. And that's just simply not correct. This legislation was actually passed by Scott McGarry, who used to be on this body. He was a lobbyist for NVBIA, and NVBIA wanted this legislation passed so that there'd be certainty in certain actions. I was on the legislative committee that empowered Scott, or charged Scott with the duty to go and amend the state code. What the state code does is it has to be the 60 days, but in addition, the person aggrieved has to have materially changed his position in good faith reliance. And in our opinion, that did not happen here. When Ms. Colt first made her complaint, they had just started framing the deck, and it would have been so easy to just move it a foot back, 6 inches back, but I don't know if the Kleins didn't know about it or what happened, but in any event, that did not happen, and Ms. Colt will explain further how this went down when she first made her complaint. Now, where the due process comes in and why Deb Colt is an aggrieved person is that in reading the staff report, there's nothing about the fact that Ms. Colt made a zoning complaint. And she made a zoning complaint, and it was given a case number. That is discussed in the court's opinion. I don't know if you all had a chance to read it. I was outside of the room because I was a witness, but it's my understanding that was important to Judge Fiore. What this case is about, in my opinion, is that if you uphold the zoning office, then you've created a situation where when a citizen makes a complaint, the county can just ignore it. And that's what was happening to Ms. Colt. She was just being ignored. And she was first told, "You're right, there's a problem here, we'll get it fixed." And then nothing, silence. And so the county's basically saying, citizen makes a complaint, we just never respond, there's never anything to appeal. You can't ever have your day in court in front of the BZA. Ms. Colt finally forced herself to Mr. Hunter, where she was told that her zoning complaint was not being considered, and that it was, in his opinion, things were correct per the building permit and so forth. I'd like to say two more things before I turn it over to Ms. Colt. The first thing I would like to say is that, back when we were here the first time, the county told you all that we were crazy to even be here. This was just an explanation, and so forth. However, I think we were right because the ordinance got amended, and it got amended to make what the county did legal. And so, I'm not trying to toot my own horn, but I think we were right when we came here, and that by legislative action, what happened is now permissible. What is not permissible, in our opinion, is that the steps, whether it's 5 feet or 8 feet, the steps are just too close. And the county says in the staff report that they had certified engineering drawings showing the steps are 5.5 feet. And, our engineering study that we had done, which is a boundary survey where the boundary was established and the distance of improvements shows that it is less than the 5 feet. And again, all of this could have been avoided if they just simply moved it half a foot from the boundary line. At this point, I'd like for Ms. Colt to have an opportunity to explain what happened.
Good evening, Ms. Colt.
Good evening. Thank you. Before I start going through a brief chronology of what happened in my complaint with the zoning office, I do want to state that I was very disappointed and frankly surprised by the complaint procedure. It was woefully inadequate. Nothing was done in writing. In fact, I was told specifically not to put things in writing, leaving no accountability and no transparency. It also made it much simpler for someone to tell me, yes, you're right, and then turn around 3 weeks later and tell me, no, everything's just fine. There was a struggle for me to figure out who to talk to because at the time I started researching this, when the problem occurred, there wasn't even a main phone number for the zoning office on the website. They have corrected that, but there's nothing anywhere that I've been able to find, and I looked at it again this past week quickly, that says how to complain about a problem. What do you do if you're the neighbor and there's what looks like a violation? So what I started doing is calling. Basically, my property is next to the one that you see up on the screen there, and we share a side property line. The issue is a second-story deck and staircase which extends to less than 5 feet from the property line, which from my last stay here for 3 hours, I understand is a legitimate setback. The deck is essentially level with the top of my fence, which basically destroys any privacy that there is between the two. By way of background, in August of 2009, I had my property surveyed and staked in preparation for re-landscaping. At that time, I had a fence installed, which you can see in the photograph there, which was set 1 to 2 inches inside the property line. And then in August of 2012, before we went to circuit court, I had it resurveyed and asked the surveyors to check that the fence was indeed not over the line, and they confirmed that, in fact, it was exactly where I thought it was, leaving the measurements as I thought. To give you a brief timeline, and I have to say that, I apologize, my early dates aren't very exact because I had no idea that this was going on. So the construction started sometime in February, and in early March, after about a month into construction, one of my neighbors approached me and said that I might want to take a look at the deck that was being framed out, that he looked too close to the property line to him. And at that point, it was a frame. It was just the outline of it, and it was clearly very close to the property line. I called the zoning office trying to determine what the allowances were for this particular property, and I was told that nothing could be closer than 8 feet on one side and 16 on the other. When I said something about a deck, I was told that decks could go up to 5 feet. What I was not told was that historically in this neighborhood, that if a deck was going to be closer than 8 feet, that a variance was required, which is something that was never applied for, and that has been changed, I understand now, in the zoning regulations. At that point, I went and measured from the fence to the deck again, and it came up less than 5 feet. And I knew that my fence was inside the property line. So I started calling around again, and I finally just pulled up the staff directory and started calling, and I decided I would talk to whoever answers the phone. I finally reached someone who answered the phone instead of an answering message, and reached Gary Green, who I understand was an inspector. He said he just returned in and he'd be happy to transfer me. He was actually very helpful. But he said, first, let me pull it up and take a look at it. He looked at the plan, there's a pause, and then his comment was, I didn't approve that, which was the first hint that there was a subtext to all of this discussion that I was unaware of. He transferred me to what turned out to be the main number at zoning. There they took my complaint, the complaint was that the deck was less than 5 feet from the property line, because that's what I understand was the regulation. The person who took the complaint also commented to me that the contractor had skipped the wall check, which may be why on my survey the deck is 4 foot 6 inches or whatever from the property line. In the Klein survey, which is dated in 2011, which was before construction started, so I assume that that's the drawing that was done with the request for the building permit. They show 5.5 feet, but that deck didn't exist at the end of 2011, so that was a projection. And in fact, that whole wall is off. If you look at, my guys measured the front corner of the wall, and it came in at 8 foot something, and the one that they had done for the application is 9 feet, so it's off all the way up the side. I was given a complaint number, CE120795. They said they would send someone out to look at it. And I said, well, I'll send you a letter in writing confirming our discussion. I was told, no, don't do that. You've got your complaint number. We'll handle it from here. Everything's fine. If I hadn't had a parent who was ill at the time, I probably would have written the letter, but I took them at their word. In late March, about 2 weeks later, approximately, I got a call from a zoning employee, Chanel Harrison, and basically she called to ask me what my complaint was and told me that I explained the position of the stairs and the edge of the deck, which actually may be referred to as a platform too, rather than part of the deck. And she said she was going to go out and check it. It was another 10 days to 2 weeks. She called me back and said she'd been out to look at it. I asked her what her opinion was, and she said, I don't know, I'm going to have to do some research. She called me back 20 minutes later with a completely different tone of voice and said, clearly quoting someone, it should never have been approved. Someone will contact the contractor and explain their options. When I asked what those options were, I was told that, well, they could probably remove it, which they wouldn't want to do, or apply for a variance. She told me that this was being referred to David Hunter, Deputy Zoning Administrator, and if I didn't hear from him or someone else in 3 weeks, I should call him. At this point, they're continuing to build the deck, and we're into the third week in April. I called Hunter, left a message saying I was checking on the status of my complaint. He called me the next morning at 8:30 a.m., and I have to confess that since I cover events that are happening in the evening, and I usually don't get to bed before 1 or 2, I was not at my best. Basically, he said, everything is fine. There's no problem. He said he had a plat from a land surveyor and asked me if I knew what a land survey was, in a tone that usually only auto mechanics talk to women in. And then he referenced, said everything was in compliance with Section 32 of the zoning ordinance. After I woke up, I called him back and left a message asking to clarify what paragraph, because I'd read it, Section 32, and I didn't see anything about decks. He called me back the next day and said that it referred to the paragraph on which was citing balconies, fascia, and trim can extend less than 8 feet. Although none of those things, to the best of my knowledge, are attached to the ground. So they can extend into the 8-foot setback. It doesn't say decks, he said, but it means decks. Frankly, I was so stunned at that point that we'd gone 180 degrees from what was, it should never have been approved, to everything is fine, that these are not the droids you're looking for, that I never pointed out to him that he was talking about something that was not my complaint, that I was talking about the 5-foot setback. At that point, I decided I needed professional assistance because I was completely confused, and contacted Mr. Lawson, who came out and looked at it and explained that there were 2 setbacks. There was one at 8 feet and there was one at 5 feet. And then talked about the history of requiring variances for encroaching decks. I've been stymied trying to have this situation heard, in part because one of the reasons that no one wanted to hear it was because it was an oral decision. And yet everything, as I said earlier, everything in the zoning complaint process is oral. There is nothing written. Nothing is given written to someone who complains, at least not in my experience. The argument was that this board had no jurisdiction, but in the 3 hours that I spent listening to other complaints and appeals and everything else, there were a multitude of discussions about things that encroached into the 5-foot setback that couldn't be done, and stairs had to be rotated, and similar changes made. As Mr. Lawson said, while we were going through the various circuit court and then waiting for the state Supreme Court to decide whether they were going to hear the appeal, the ordinance was rewritten so that the 8-foot, the incursion into 8 feet is fine. However, it is still less than 5 feet from my property line, and the impact of that with a second-story deck is tremendous. You have someone staring into your yard. After my appeal here was not heard the last time, I had some trees put in for at least temporary screening, which was an expensive and complicated process because I ended up having to also reroute my irrigation system, and it ruined my security lighting in the driveway. But it still is noticeable even with the trees there. Okay, that's, I guess, what I wanted to say. Thank you very much for listening.
Thank you, Ms. Holt.
Mm-hmm.
Anything further, Mr. Lawson?
The only thing is I'd hand out for the record 15.223.
Let's see. Thought that was cited in the information we have here, but thank you very much. I believe now we would hear from the county.
It's up to you. All right. Good evening, members of the Board of Zoning Appeals. Would you like me to? Okay. All right. I'm spread out here, so just, if you will, give me a few minutes. That's all right.
And actually, fill out a speaker slip, any chance? Does she have to? Mr. Lusher represents the applicant, so I usually have a slip, just so we have it for the record. But as long as Mr. Noxon knows who you are, and I think he does, I think we're good. But we will ask you to state your name and...
Certainly. My name is Christine Sanders. I'm an assistant county attorney, and I'm here representing the zoning administrator. You've heard a very interesting story this evening from Ms. Colt and her attorney, Mr. Lawson. One of the interesting things about the Board of Zoning Appeals is there's no rules of evidence that apply, so you can hear anything, essentially, regardless of whether there's any basis to hear it in front of you. I want to just, if the Board of Zoning Appeals will, understand what we're here for and why we're here, and that was an appeal of the zoning administrators or the deputy zoning administrator's oral statement that he made to Ms. Colt in March of 2012. It has nothing to do with a subsequent survey that was just handed to you and me this evening that may or may not show certain facts are in dispute about the location of this particular deck. It has to do with a conversation that occurred in March of 2012. I think that's why we're here. We want to stay focused on that. I would like to essentially state that, as you all know, the facts came about such that the Kleins asked for and received a building permit to build their addition, including their deck, in January. At such point in time when Ms. Colt became concerned about it, sometime in March, and started to make inquiries and complaints about it, that permit had already been issued. That was the determination that was made at that time. When the Kleins came in and said, this is what I want to do, here are my plans, here's my survey, as is normally the case, it gets submitted to zoning, they review it for compliance with the zoning ordinance, and they either approve the permit or they don't. In this case, they approved the permit, and that actual determination happened in January. The complaint later came to you, to the zoning office in March. At that point in time, more than 60 days had elapsed. That permit was final, and as Mr. Lawson points out, that's why we have 15.22311C, because there has to be some finality in these situations. Landowners who come in and ask for a permit or ask for a determination about whether or not they're trying to do something, especially in this case where it's allowed by right, they have to have some finality in that. So there's nothing that could have been done to really undermine it. I want to really just go back to the fact that what we're asking you here today is to focus on the fact that a complaint was made in March, a conversation was made with the deputy zoning administrator. At that point in time, Ms. Colt was not considered an aggrieved party under 2311. Her rights weren't being affected. She had no pending application before the zoning administrator that could be acted upon. And the quote, conversation, if you will, that she had with the deputy zoning administrator wasn't a determination that could be appealed under the law. So we're here today to ask you to find the fact that Ms. Colt isn't an aggrieved party under the law. There's no determination that was made in March that could be appealed, because that was basically an explanation of what had occurred previously in January, and that the building permit was properly issued. I'm happy to answer any questions about that. If there are none, I'll sit down in case some others come up.
Madam Chair, I do have one question, and thank you, Ms. Sanders, for being here. Does the county have a position on notice of the award of the building permit? Is that a red card that's posted?
Oh, the building permit is required to be posted, absolutely.
So your position is that gave Ms. Colt notice?
That's all that's required.
And the county's position is that was carried out by the next door neighbors, the Kleins?
To the best of our knowledge, even Ms. Colt herself told you that she knew that the building was going on in February. So if she had some concerns about...
Your statement was January. February might be within 60 days. January, I think the materials from the appellant say March 15th. So if building didn't, if there wasn't a posting of a building permit having been granted until January 20th, then she was within the 60 days. Do you have some position on whether there was that posting of the building notice that would have given the public notice that
If I understand your question correctly, we're not sure exactly when the building permit might have been posted, therefore Ms. Colt might not have known until she saw the building or the construction occurring. Is that correct?
Okay.
I was interpreting that the 60 days of notice, at what point, I think Mr. Smith is asking, at what point does the county believe the 60-day notice from the building permit begins to run to capture any question of when Ms. Klein's complaint was made? Was it made in any way within that 60 days?
Because the determination here is the issuance of the building permit and it deals with the property rights of the Kleins, we submit that it would be 60 days from the January 4th issuance of that building permit. Those are the property rights that are at issue here. That would be, quote, the aggrieved party under the case law, and that's been cited for you previously. And so it would have been 60 days from that time frame.
But a party's not required to start building the day they get the building permit, is that correct?
That's correct.
So they could withhold posting that building permit until the 61st day, and under your interpretation, therefore, citizenry would have no standing to challenge any building at that point, because the 60 days will have elapsed.
I'm not suggesting that she doesn't have standing. I'm suggesting she's not an aggrieved party under the determination that the building permit was issued. In other words, it was issued appropriately. It was issued, what happened was they came in, they brought the surveys, they looked at it, they saw that it complied with the ordinance. It was a by right issuance of a building permit. And so to the extent that those are the property rights that you have to look at, and that Ms. Colt unfortunately doesn't fit the legal definition of a party who's aggrieved under this particular statute. It is not her property rights that are wrapped in that building permit. It is the Kleins. And so
your position would be consistent with what Mr. Lawson said, which is the county doesn't care about any adjacent property owner having rights to complain about the improper building of a structure.
I think that's probably going a little too far. I think that the county does care. I think that...
Well, you say they're not an aggrieved party, so under your interpretation, they would have no standing to raise that issue. They could never be an aggrieved party.
When it comes to the issuance of the building permit, unfortunately, that's correct. Unless there was some fraud or mistake that occurred, and those are the only two things under 2311C, the county looks at what's put in front of it, and then for whatever reason, the Northern Virginia building industry decided that needed to be a final determination so that rights could vest as of that point in time. And after that, then the client's rights are vested.
Let me go back to another issue, because the county's position appears to be that the building permit was properly issued, and yet we do know that the ordinance was amended to subsequently bring that issuance into full compliance. So as a matter of fact, in these facts, isn't there a circumstance where that original building permit was not properly issued?
I don't think that just because that the ordinance was amended that it indicates that there was something that was done improperly. I think it's an interpretation that's been long-standing that the county decided needed to just be codified so that it would be clear. It doesn't need to continue on as an interpretation. Zoning ordinances, as you all know, are fluid documents and need to be amended over time so that these interpretations can then become part of the ordinance, and that no longer are you needing to have a specific interpretation about something that continues to come up as a question again and again.
But to the point that it was coming up as a question again and again, isn't each interpretation of that prior to the codification an actual interpretation?
Yes, but it's a consistent one. So it's not...
And I guess I haven't heard any testimony with regard to the consistency. Could you speak to that? I mean, you've made it...
It was in the report. We did furnish to you the zoning ordinance. It's been the same since, I think, since the 1950 ordinance, and then it was recently codified, I think, in June of this year, just to change that. But as far as Ms. Cozart's concerned, since she's been a deputy zoning administrator in 1999, that's been a consistent application of the interpretation of whether or not a deck or stairs are interpreted to be a platform and can encroach within the setback so long as there's 5 feet from the property line.
Right.
So I do feel like there's some evidence in front of you in the staff report.
But I appreciate that. But my point was, the zoning administrator, in the absence of actual codification, still was vested with that authority. Isn't that correct? To make an interpretation?
Absolutely. The zoning administrator is vested with all authority to interpret the zoning ordinance.
And notwithstanding the fact that there had been longstanding practice, the potential for a zoning administrator to make a different determination exists prior to the codification.
That's correct.
Okay, thank you, that's all I.
Sure.
Anything further? Not at this time, but we may need you back, so, but you can have a seat. I believe we also have other witnesses on this matter. So why don't we hear, I think we have applicants, the Kleins are present as well, and I'd like to hear from both of them. Sarah Klein, 3401 North Piedmont Street, speaking in favor.
Hi. I'd like to request more than 2 minutes, please, since this is my house that we're...
I think at this point it'll be 2 minutes, and then if we have some additional questions, which we may have, then you'll have more time. But if
Okay.
you could summarize, this is,
Well, I guess the first thing I would like to say is with regard to notice that the first time I met my neighbor, which was in September of 2011, before I even closed on this property, I mentioned that we would be doing construction, and she mentioned that she had fully anticipated that whoever bought the house would do construction. And so she was on notice that construction would occur, and when our permit was issued, we posted it immediately. Our builder is here and can also testify to that. We began construction immediately because we owned another home in Arlington County. We're 20-year Arlington County homeowners, and we built this house as quickly as we could in compliance with the zoning ordinance. We never requested a variance because none was needed. With regard to our stairs, tonight is the first time I have heard my neighbor say that the stairs are less than 5 feet from the property line. I have not seen the survey that was given to you tonight. If a survey was taken of my property, it was taken illegally. And we did conduct a wall check on April 12th of 2012. We submitted it to the zoning office, and it was accepted. I have it with me tonight. I'm happy to give it to you. But the zoning ordinance has at the time that we applied for our permit, at the time that we built our house, today, it allowed decks and stairs leading to decks to encroach into the setback as long as they weren't closer than 5 feet. And our stairs are 5 feet, so they comply. We've heard a lot about party aggrieved and is the conversation a determination. What is truly important to me, because this is my home and it's taken up a lot of my time and energy and money for the last 2.5 years, is that our stairs comply. So I would ask the BZA to please make 2 findings tonight: 1, that our permit was properly issued, and 2, that our stairs as built are in compliance. And if you'd like to see the wall check, I have it.
that'd be great. Do we have any questions for Ms. Klein?
No, you're going to give us your
I'm
wall
going to
check?
give you the wall check right now.
Appreciate that. And Madam Chair, did you see the plat that?
She said she hadn't received
Oh,
that.
okay.
So, but Mr. Knox, I believe, has an extra copy if you want to get a copy of that, I'm sure, of the survey. Thank you. Well, if he put in a speaker slip, Ms. Klein. Okay, thank you. So the next speaker would be Stephen Klein, also 3401 North Piedmont Street, Arlington, Virginia. So together you get 4 minutes, so. Okay, Mr. Klein.
Thank you. I'd like to read the statement of support as to the appellant being a aggrieved person. This was filed by Mr. Lawson back in 2012. Appellant contends that the stairs that lead to the deck are structures and must be located 8 feet from the side property line. Goes on, decks and the steps that lead up to them have always been considered structures and not platforms, and are not allowed by the zoning ordinance to encroach into the side yard setback. These steps are clearly in violation of the side yard setback of 8 feet and are in violation of the zoning ordinance. This has been a consistent interpretation by the zoning office for many years, that steps can be up to 5 feet from the property line. Tonight is the first time that Ms. Colt has said anything about the decks, the stairs being less than 5 feet. In fact, the interpretation that she wanted you to make 2.5 years ago was we could build the deck up to 5 feet as long as there were no stairs there. You've heard a lot of misinformation tonight, but we had the wall check back in 2012. We submitted it to the zoning administrator. If anyone came onto our property without our authorization to do a survey, it was trespass, and it shouldn't be accepted by this panel. As my wife said, we need you to talk about the permit being issued properly and that the stairs as built comply with the Arlington County zoning ordinance, both the zoning ordinance that was in effect in 2012 when we built this house and the zoning ordinance that was amended consistently with the earlier one back in June. Thank you very much.
Thank you, Mr. Klein. And we did receive another speaker slip, although I don't believe it's the right number, but is, okay. So I'll keep both of them. You're here for two cases? Okay. So Yurgay Sagatov, 3689 North Harrison Street, speaking against, I guess I have you.
I'm the permit holder for the Kleins, and I would just like to explain the process of what happened during with the wall check. We initially submitted an initial wall check.
Well, actually, would you mind backing up and
Sure.
starting with what point you became involved in the process and everything you know about the process that could be more helpful to us?
Yes, ma'am. I'm the design build firm that was hired by the Kleins to design and construct their home at 3401 Piedmont Street. So the plans were developed based on the current zoning laws of the time and our interpretation and what the consistent interpretation of the zoning administrator was regarding steps and landings into the setback. So it was designed to be within those guidelines. It was built per the plans. I received a call at one point from one of the zoning inspectors asking to get a wall check submitted. We had a wall check done. The initial wall check actually showed that the steps were 4.9 feet from the property line. So we actually rebuilt the landing and then had the wall check redone. That's why you can see the Klein. There are two dates on that wall check from the Kleins. The initial one was done. It was 4.9 feet. We rebuilt the steps to make them 5.0 feet. The wall check was updated, submitted, and approved by the county.
Okay. Anything further you want to tell us about this process?
That's it. I'm just here to answer any questions that you may have.
Okay. And I don't think I have any others. Any other questions? Thank you. That was very helpful.
Thank you.
Madam Chairman, I'm sorry.
Russell.
Can you recall what day you posted the building permit?
The building permit was issued on January 4th, and I don't have the exact day, but we started construction within 7 days of that being issued. And I do have a photograph of the building permit in the window with one of the first days of demolition with me. It's not dated, unfortunately, so I can't testify to the exact date.
But to your recollection, it was in January?
Yes, ma'am.
Anything further? No, I think that's it for now. Thank you. Mr. Lawson.
Thank you, Madam Chairman. Very briefly, I've been involved in a number of these cases on the other side where I'm representing the homeowner who has run afoul of the zoning ordinance. And in almost every one of those cases, we've had a permit issued. And for whatever reason, it turns out that it's not 8 feet, it's 7 feet, 11 inches, or whatever. And in every one of those, the zoning office hasn't said, well, we issued the building permit 60 days, so you get to keep it. Every time I've had to go back and fix it. And the reason I have is that the county, until this case, has taken the position that 15.22311 only gives you rights if the drawings are accurate. So if you submit drawings that are inaccurate, then you can't obtain any rights under that code section. I did one case where the architect simply misadded, and a garage was 6 feet from the property line rather than 8. and I had to secure a variance for that. I had Susanna Micardo, who built her house 1 inch too close to the property line. We had a surveyor there, and we had a guy with a brick grinder grinding the bricks. And then when the surveyor said, okay, you're 8 feet, he quit grinding the bricks. And so the point that I would make is that, again, we go back to surveys. And what Deb Walker got is a boundary survey, not a house location survey. Everything has been a house location survey, which do not correctly establish where improvements are vis-a-vis property lines. A boundary survey does. And so I think that what I would submit is that if it doesn't accurately show the distance from the house to the property line or from the steps to the property line, then you can't claim vested rights under 15.22311. Thank you very much.
Mr. Lawson, in your prior cases, have you relied on the surveys the surveys we received from the clients, or have you done the bounded surveys that you just discussed?
I'm sorry?
In the past, the cases that you started talking about where you represented homeowners on the other side, what type of surveys did you submit to the board?
Well, I didn't submit anything, but in the past, the owners often use house location surveys. Whenever I get into a case, the very first thing I do is get a boundary.
And how is that obtained, given the question of the legality of obtaining those? Do you have to go on the property of the clients to get that type of survey?
I don't believe so.
Okay, could you just put,
I'm not the engineer, and I didn't do it, but the engineer was specifically instructed to establish the boundary and the distance of improvements, and that's what was done. But I don't know how the engineer did that.
Okay, thank you.
Okay.
Anything further? None. I think we're ready for deliberation.
Madam Chair, I looked at the letter opinion by Judge Fiore of the Arlington County Circuit Court, and it asked that we answer some questions, which is kind of unusual. In generally, we're asked whether the determination of the zoning administrator was correct. So our answers are usually yes or no,
But don't the proposed motions answer those questions? Or do you think we need to put something else on the record?
Well, so long as the proposed motions answer specifically the questions presented that are outlined that are written on page 2 of the judge's opinion.
Why don't we go through those questions for the record, and I'll look at against the resolutions that have been proposed.
And the first being, number 1, did the zoning administrator make a decision regarding a zoning ordinance as to which Colt alleged she was aggrieved? And number 2, did the Board of BZA hold a hearing on Ms. Colt's application for appeal? And number 3, was the BZA required to hear Ms. Colt's appeal, or could it summarily dispose of the appeal without holding a hearing?
Well, I think we can start in reverse order.
I agree.
And I believe that the board, by hearing the case tonight, is answering that, as both I believe you and I answered that the last time, which is no, that we needed to have the hearing on the legal issue regarding the determination and make factual findings. So to the extent that the board is affirmatively hearing the case this evening, we've made a determination that it was appropriate for the board, in fact, to take evidence, hear facts, and we will be rendering a decision from that determination. As to the first question?
Yes, more problematic. Did the zoning administrator make a decision regarding a zoning ordinance as to which Colt alleged she was aggrieved?
And I think we need to substitute the deputy zoning administrator who was acting with the authority of the zoning administrator for that. Thoughts of my fellow board members on that specific question? Mr. Russell?
I thought that was the point, that the deputy zoning administrator could not make such.
And that's why I specifically note that may be one of the conclusions we make, that unlike what the circuit court ordered, that we're talking not about the zoning administrator, but the deputy zoning administrator, but is it the fact that he has no jurisdiction because he's the deputy zoning administrator? Or would it be factually because, as what's written in the proposed resolution as it stands, that that it was not a determination? So those seem a little bit different to me. I don't think we've ever asked the question, did he have the authority to make the determination? And that's not what's in the resolution right now.
Yes, and it's something for this board to discuss.
Right.
And I would
Answer that
suggest,
question.
and Madam Chair, I'd suggest that it was a conversation. It was the reply to a question, that it wasn't a determination as contemplated by the statute.
Ms. Freshman? I mean, is Freshman?
No, I essentially agree, and I think that I don't think we can settle the legitimacy of the distance from the property line, given how many different opinions we have and how many different surveys we have. We don't really know that. But as Mr. Lawson pointed out, if in fact there was an error and it is closer than 5 feet, the property owners can certainly request relief for that. That's a different issue completely, in my view, from the process that we're talking about now.
Mm-hmm. And your thoughts as to the question of the authority of the deputy zoning administrator vis-a-vis determinations?
Well, I think I agree with Mr. Smith that it wasn't a determination. There was a conversation, discussion that was certainly responding to a complaint, but not, I don't find that she's an aggrieved party.
Mr. Russell?
No, I don't either. I think that begs the question, where then does that stop as you go down the line? You talk to a staff member. If that were the case, and it was my office, I would begin to instruct staff not to talk to anybody about. So in this instance, there was an overabundance of information back and forth in different ways. It seems to me on the specific point of the deputy zoning administrator opinion over the telephone constitute a determination or an interpretation, when in fact the permit had been issued which established the zoning administrator's determination, signature, paperwork, sign off in computers, building permits issued, and so forth.
Yeah, and I guess for me, I would take the comments of my fellow board members and add them both together and want to look at the resolution that's been proposed to amend, because I think there's two facets that have been discussed. One is that it was an oral statement that was not a determination for the reasons Mr. Russell just said. That is that the determination and the point of the determination is at the issuance of the permit. And secondarily, the question being whether there would be any authority of the deputy zoning administrator to make a determination. And I think I don't think there's, even if this had been prior to the issuance, the question would be, can an oral statement by the deputy zoning administrator bind the county? And I don't believe that that's possible, unless that's been specifically delegated in a certain circumstance by the zoning administrator to the deputy, which there's been no evidence here that that would have been the case. So, I think that it's an additional point that is not really specifically articulated in the circuit court's decision, but that was a concern for me. And that's one of the reasons I asked about the determinations from the county, and their view on regarding determinations is because, to me, who's making the determination is relevant to the issue at hand. And I think we've also said that the rights go to the issuance of the permit, not necessarily the issuance of any complaint process, which Ms. Colt has properly brought to the attention of us, but I don't believe is really the issue before us, because our only issue is the determination, was the permit properly issued? Was the determination of the zoning administrator correct in the issuance of that permit? And did we answer all three questions?
Well, essentially, the first is going to, was Ms. Colt aggrieved? And then, Did we hold a hearing? No, we didn't. That's number 2. Number 3 was the, can the BZA summarily dispose of an appeal without a hearing and deciding? So, Madam Chair, I am now comfortable with making a decision, a determination, and essentially I would uphold now the zoning administrator's subsequent determination that the conversation by by her deputy was not a determination, that Ms. Colt was not aggrieved, that we have now had a hearing on the merits, and that ultimately the determination of the zoning administrator was correct.
And I guess then we need to look at the proposed resolution, because I don't know that it is capturing the exact position of the board. I think the first 2 paragraphs are appropriate. The 3rd paragraph, I don't believe the findings of the board are that she was not aggrieved by the statement because the statement could not affect her property interests or legal rights is exactly correct. I don't believe that paragraph is accurate.
I agree.
Nor do I believe the 4th paragraph is accurate or relevant.
I don't think it's relevant or really necessary.
So I think, as I look at the proposed resolution, a 3rd paragraph should be, whereas the BZA finds that the deputy zoning administrator had no jurisdiction to make a determination, Ms. Colt was not aggrieved by the statements made by the deputy zoning administrator.
Authority or jurisdiction?
Did I say jurisdiction?
Yeah.
Oh, no authority.
Okay.
What are the thoughts?
And strike number 4.
I actually should be receiving that from you. I shouldn't.
Well, and then therefore be it resolved. That's really pulling it together. This resolution is asking us to affirm the zoning administrator's issuance of a building permit. The building permit was never challenged. So I don't.
Well, I mean, I think that to the extent that the fundamental reason that Ms. Colt brought the case was because she's arguing that the building permit was improperly issued to the extent that it was encroaching originally into the setbacks that she felt was inappropriate. That's how I would take her complaint. So,
Well, I guess we have testimony by the county that, and by Ms. Klein, who the recipient of the building permit, that it was posted immediately, construction began. There was a discussion earlier, months earlier, about proposed, that construction was going to ensue, and we have nothing that contradicts any of that, and I fully believe that.
Plus, we have testimony that the building permit was not improperly issued and that it was in accordance with the practice of the county and not a deviation from that.
I guess I'm hearing 2 different things. We're looking at the proposed suggested resolution, which addresses certain topics, and then we're discussing the questions in the letter. Mm-hmm. And which pieces are we going to talk about in the resolution? If it's important from a legal point of view, for example, that we address these 3 questions because we think that that's the directive, then the resolution should reflect that, which it reflects issues that have come up in conversation and have been elaborated on in the staff reports, but they're not the same thing. They're not the same 3 items. So I guess we need to decide which questions we want answered before we can craft a resolution or modify the one that was proposed.
Well, and I think we were working on modifying the one that was proposed. And as to the first paragraph, I think it answers question number 3, and we could add additional language into the first paragraph of the proposed resolution. Whereas the Board of Zoning Appeals has determined that a hearing is necessary and therefore has held a duly advertised public hearing on November 12th.
That handles 2. It seems to me that handles 2 of the questions that court says need to be answered.
The first whereas.
Yes.
Okay. It answers 2 and 3?
Yes, I think it does. And then my point as to 1, with regard to the zoning administrator's determination, or 2, point 2, with regard to the zoning administrator's determination, the resolution should clarify that we are ruling on the zoning administrator's determination as rendered by the issuance of the building permit, and that was correct. And secondarily, we are finding that the deputy zoning administrator had no authority and did not make a determination because it was subsequent to the issuance of the determination, which is documented by the building permit.
First 2 apply, but then another has to be drafted.
Right.
But not 3 and 4.
No, not 3 and 4. Would be, does everybody agree, strike 3 and 4?
I do.
Yikes.
3 and 4, which one? This one,
Proposed.
alternative of
No,
proposed.
the suggested resolution.
So that would be striking, whereas the BZA finds that Ms. Colt was not aggrieved?
Not by the statement.
By the statement of the deputy zoning administrator.
Okay, so you were cutting that one. Just to make sure I understood. I see.
I mean, I think we have to add a paragraph that says we're making a finding that the determination of the zoning administrator was the issuance of the building permit on January, whatever the date was, right?
Number 4 is partially says that. You don't talk about the deputy zoning administrator. So you're saying the building permit is correct.
Yeah, whereas the,
So Mike is not on.
Sorry. If it's our intent to include a statement that the building permit was properly issued,
yeah,
then that,
so we could change, okay, so whereas the
Does-
BZA finds that the issuance of building permit was correct,
for the basis of the approval.
I don't know that we need the basis of the approval. The issuance of the building permit
Well, that's the first part of 4.
was the determination of the zoning administrator.
That's true. I agree.
Okay.
And that can be the second paragraph.
What?
Who has
You're just
the discretion
reordering
to
them?
interpret the decks and stairs as being the type of a platform. So we just take out reference to the deputy zoning administrator's explanation and affirmatively make second paragraph that, because that's our finding, that everything turns on the fact that the determination is tied to the issuance of the permit.
So does that become the first one?
That'd be the second one. The
Second.
first one's that we held whereas the BZA has determined that a hearing is necessary and therefore held a duly advertised public hearing.
Okay. And then the one that's currently the second one?
Would be the third one.
Okay.
And I think on the third one, we could simply add, was not a determination because it was an informal statement explaining the issuance of a building permit issued more than 60 days prior to and not, building permit issued more than 60 days.
It's a valid permit.
Well, the issuance of a building permit,
Issued on January 4th, 2012, and not a final decision. And that way, you don't have to say more than 60 days, because you're referring to an...
right,
on
to our
April
first finding, January what?
4th,
4th, 2012, and he did not, and the deputy zoning administrator did not have authority
Undo it or challenge it.
to render a contrary decision,
it's kind of the
render a contrary determination
first one. judges, kind of, that's the way I look at it.
period, comma, and then that fills it. So if you put that all in the paragraph, yeah, so there's only 3 whereases, but in the third paragraph, whereas, we're putting both facts that we have about the zoning administrator, deputy zoning administrator. Therefore, be it resolved, the BZA affirms the actions of the zoning administrator, take out the apostrophe, in issuing building permit, finds that the oral statements of the deputy zoning administrator was not a determination, and he had no authority to change the zoning administrator's determination. And Ms. Colt is not is not aggrieved under Virginia Code 15.2-2311.
Madam Chair, including the whereases, I think that the amended whereases, I think that encompasses the questions the circuit court remanded back to us, and I agree with that wholeheartedly.
So are you,
So, Madam Chair, I would move that the Board of Zoning Appeals adopt a resolution which is described as follows. Number 1, whereas the Board of Zoning Appeals has determined that a hearing is necessary and therefore held a duly advertised public hearing on November 12, 2014 on case number V-10681-12-APP-2, an appeal of a deputy zoning administrator's oral statement explaining the basis for approval of building permit number B1103180, and number 2, whereas the Board of Zoning Appeals finds that the issuance of building permit B1103180 was the determination of the zoning administrator who has the discretion to interpret decks and stairs as being a type of platform. And number 3, whereas the Board of Zoning Appeals finds that the statement made by the Deputy Zoning Administrator on April 25, 2012 was not a determination because it was an informal statement explaining the issuance of a building permit issued on January 4, 2012, and the Deputy Zoning Administrator did not have authority to render a contrary determination. Now, therefore, be it resolved that the Board of Zoning Appeals hereby, number 1, affirms the actions of the zoning administrator in issuing building permit B1103180. Number 2, finds that the oral statements of the deputy zoning administrator was not a determination under Virginia Code 15.2-2311. And number 3, Ms. Colt is not
and that he did not.
And that he had not the authority to change the zoning administrator's determination. And number 3, Ms. Colt is not aggrieved under Virginia Code section 15.2-2311.
Second.
Been moved and seconded. All in favor?
Aye.
Aye. The amended resolution passes. Thank you very much for bringing this to our attention. Now, I would say, as was recognized, should the determinations be made that something is not within all the documents that we have, that's a separate issue, and that would be addressed separately should the structure not be built in accordance with what was there. But that's not what we were discussing today. At this point, your permit's good, your building's good, everything's okay. Okay.
Okay. I'll proceed with our next case.
Next case.
It's V-10595-11-UP-3. This is a use permit amendment request by Scott Epping Christensen to permit a setback of 17.9 feet to the eave and 18.8 feet to the porch space from the North Larrymore Street right-of-way instead of 25 feet as required. It's for the reconstruction of a front porch that was approved by a previous use permit. It's in the R6 zoning district on a premises known as 1013 North Larrymore Street.
And the recommendation is to adopt the attached resolution approving the subject use permit with conditions. Are any questions of staff? Okay, seeing none, are Scott or Eppin Christensen present? Mr. Christensen, welcome this evening. You've seen the recommendation of the staff. What else do you want to share with us this evening?
Nothing to share unless, Madam Chair, you or the other members of the board have any questions for us.
All the discussions on decks, just make sure it's built right.
Yes, ma'am. That's what we're hoping to correct.
Madam Chair, I would just say, even though the applicant has not gone back to the neighbors for their consent, if you will, the representation that this is just a different design with the same setbacks, it, to me, satisfies the condition that that the neighbors really be informed and that it not be of substantial detriment to them.
Mr. Christensen, did you contact the neighbors or this time around?
Not about this particular change. As the record should reflect, we have the consent of neighbors on both sides across the street and our civic association for the construction that you see on the screen. And the proposal is to, in fact, open it a bit more and make the design on the same dimensions, but more consistent with the current design of the rest of the house.
Okay, great. There are no further questions. The chair's ready for a motion.
I'd stand corrected by the person from whom I'm often corrected appropriately.
Ms. Christensen, Eppin, I imagine?
Yes, we actually have talked to our neighbors. Our neighbor, if you're facing the house to the left, are very close friends, and they actually were over there yesterday, spending all day, and we have discussed extensively, what we're going to do, because we both like renovations in general, but we have told them what we wanted to do, and they know what the problems are. In fact, because of the poor construction, they're often the ones who are tripping over some of the problem. I mean, we didn't want to reconstruct it, but it's built so poorly that we have to. So they're aware of it, and we also told our next door neighbors. They just moved out of the home. They moved into Sunrise Communities, so that's we didn't want to go and ask for them. But we have kept both sides. We're friends with both sides, and they're well aware of it. And then they said if we wanted to have their statements, they'll be happy to provide it.
Thank you. As was pointed out earlier, we take representations here, and unless they're contradicted, that's what we decide our cases on. So we appreciate your giving us that information.
Thank you.
If there's nothing further, I think I'm ready for a motion.
Madam Chair?
Yes.
I move that the Board of Zoning Appeals adopt the attached resolution granting use permit V-10595-11-UP-3, subject to the conditions listed in the resolution.
Second.
Been moved and seconded. All in favor?
Aye.
Aye.
Given that I was out of the room, I will abstain.
Well, you read the report. So the record should reflect 3-4 and 1 abstention, Mr. Noxon. And the motion still carries. We move to the next case, Mr. Noxon.
Okay. This is case number V-10949-14-UP-1, and this is a use permit request by Keith Oberg and Jessica Mott. Permit a setback of 4 feet to the left side property line instead of 5 feet is required. This is for a new air conditioning unit in the left side yard. It's in the R6 zoning district on a premises known as 3108 17th Street North.
And the recommendation is to adopt the attached resolution denying the subject use permit. An alternative resolution has been provided should the BZA wish to approve the request. Okay, actually, before we get to you, we might ask the staff if they have any questions of the staff first, and then we'll have you come up. Of course, I should have asked if we had any questions while he was standing there.
Madam Chair, I don't have any questions. I think in their staff analysis, they've described their position.
Mm-hmm. No other questions? Okay, so Mr. Keith Oberg, 3108 17th Street North.
Good evening,
Okay.
thank you. I'm here with my wife, and I'm sure she'll remind me if I forget anything, but we're talking about 1 foot, and there's precedent in the immediate neighborhood, without going very far, both mentioned by staff, the variance that was previously granted by the Board of Zoning Appeals, and also an additional home on the other side, that also, both of those cases are closer now than 5 feet to the side property line. And the second photo provides evidence of that second case that I refer to. There may well be others in the neighborhood. We disagree with the staff assertion that it may have noise impact for a number of reasons. In our application, we referred to the compressor, which has extra silencing characteristics. It's a high-quality one, and if you want the exact information, I have that. And second, that by moving it from the current location, we have to move it because of some, it's slightly blocking egress with expansion of a door out to the back. Moving it from the south side to which is the south side facing the sun and getting heated, moving it to the east side would reduce the heating up during the summer and would actually keep it from operating more. It would actually reduce the time that it would be operating. Number one, that would be less noise because it would be operating for a lesser time. And number two, it would also be less pollution, less energy consumption. And for that reason, for many reasons, it would be contribute to the greater health of the community and to lesser impact all the way up to global warming. We have no objections from the neighbors, including the immediate neighbor, who would be affected by it. And not only does he have no objection, and we have a list there of all the neighbors who have signed, but he happens to have his air conditioner on the side of the house, as on the same side of the house as we would, but his property includes his driveway. So it would be the same, but we would be disadvantaged. Again, we're talking about just 1 foot. In other words, it would be 4 feet from the property line rather than 5 feet, and it would be covered by a fence, so it would not be visible. So, turning down would adversely affect the health in terms of noise and increased pollution. It would not. There's precedent for in the neighborhood. It will not affect negatively affect property values, and so it's consistent with neighborhood practice. So.
Can I just ask, is the size of the unit you're putting in 3 feet? Is that the size of the unit? Because you say that it's 4 feet from the fence and 1 foot from the house. So I'm assuming you're saying it's a 3 foot.
Right, 3 feet by 3 feet, I believe. I'll have to Okay, yes.
I assume that was the case, because you have 8.3 and 8.8 feet along that side of the house.
Right.
And you have
it's-
less room on the other side. That's correct. You only have 5 feet on the other side of the house.
Right, yeah.
But you're moving it from the back of the house.
From the back of the house where there's, right, yeah, on the south-facing side. So, and we have, a professional opinion, and I can get additional professional opinions on, location makes a difference in terms of energy consumption.
Yeah, we saw that in your application. Thank you very much. Any further questions? Yes, you may come up and you may speak as well, Ms. Jessica Mott.
Yeah.
I just wanted to mention the 5th photo in your packet shows our neighbor, the immediate adjacent neighbor, and the driveway, and you can see the fence. Our fence completely hides it from it. He personally came and listened to it and agreed, that this would be perfectly acceptable to it. And I do think that Arlington County is a county that believes in doing things environmentally soundly and for that greater benefit. And this is a case where a decision to accept our proposal really would be in accordance with wider county policy. And it is something that's there's no reason none of the neighbors disagree with it. Everybody's in agreement on it. We were sort of saying, well, maybe we should have also, I'm sure we could have gotten the Lion Village Association, supporting it as well. But we didn't think of that. But
Oh, Ms. Mott, let me just say, though, that the ordinance is what it is because of the setbacks that are necessary to minimize the harm. So even though we're talking about a foot, we often deal in inches and not in feet. So for the Board of Zoning Appeals, that really isn't a compelling argument that it's only a foot. I think that it's just important to understand that as we look at these issues, the setbacks are set for a reason, and unless we find a reason to make a different determination, we really are bound by what the ordinance would say.
right, but I'm pointing out the shade. The shade, there is a difference in circumstance. So rejecting this proposal potentially causes harm because we will have more pollution and more noise to the wider environment for the county. And so putting it in a shady area is something that is to the public benefit and health, and there is a positive reason to accept our proposal accordingly.
Thank you. If you'll have a seat, I think we're ready to deliberate. Mr. Noxon, have you had a chance to look at the sightings of the other air conditioners as presented by the applicants? I'm particularly interested in the one at 3118 17th Street North.
See where that one is.
Do we know if we had a permit request, if it's truly less than 5 feet?
3118.
It's a second picture in their packet.
I believe I looked that one up and saw a permit. It was an older one stating it was right at 5. The only issue with those is when they get approved, sometimes contractors, tell you you've got to be 16 inches off the house, 1 foot off the house. They go ahead and do it. We have no way of confirming that it's meeting the 5 feet unless somebody complains and we have a wall check done. So that's probably one of those instances where we've issued a permit for 5 feet. It may or may not have been placed at 5 feet.
But you have no instances where anyone's requested it has come before us to request different placement than the 5 foot.
Correct. Not on that. We just have the one case, that I've specified here, the 1998 variance at 3110 17th Street North.
Right, and we see that one, that's the first picture. And the last one of their neighbors is clearly well beyond the 5 feet because of the driveway that they speak of.
Madam Chairman,
Mr. Russell?
ask Mr. Knoxon a question. I'm looking at the plat. Am I correct in understanding that this lot is 55 feet wide in an R6 district?
Let's see.
What is that?
That is correct.
So although that it is 6,000 square feet, which is the area that's required, it's narrow in respect to the ordinance, which was set in 1950 after this lot obviously was platted.
Correct.
Then it would have been 60 feet wide, which I submit there could provide the additional feet to put it correct, and
correct.
therefore be
Absolutely.
a reason to give some relief. It's too narrow.
But which also argues that that's why there's room to put it in the backyard, which is where it's at, because it's too narrow.
Madam Chairman, I'll be glad to make a motion if we're ready.
Sure.
I move that the Board of Zoning Appeals adopt the alternative resolution in the staff report, which approves the approves a use permit as requested by the applicants for a permit to place an air conditioning unit 4 feet from the left side property line instead of 5 feet as required and subject to the conditions in that resolution.
Second.
Been moved and seconded by Ms. Freshman. All in favor?
Aye.
Opposed? I'm going to vote no. No abstaining. So 3-1, motion carries.
Okay.
You can place it there.
Next case tonight is V-10950-14-UP-1. This is a use permit request by Timothy Hayes and Nancy McEldoney. And this is to permit a setback of 4.4 feet to the cornice and eave and 4.9 feet to the porch space from the right side property line instead of 8 feet as required. Also an aggregate side yard of 14.9 feet instead of 18 feet as required. And this is for a new front wraparound front porch. This is in the R6 zoning district on a premises known as 1601 North Fillmore Street.
And the recommendation is to adopt the attached resolution approving a use permit for a setback of 5 feet to the porch from the right side property line. And an alternative resolution has been provided should the BZA wish to grant the use permit as it was advertised. Questions of staff?
Madam Chair, just one, one question of staff. Currently, there exists a side yard setback of 4.9 feet, correct?
That's correct.
So this is not expanding, encroaching any further into the side yard.
Exactly.
And the design is, it's not square. They're actually building, or they're proposing to build this porch with kind of with a sliver cut out, such that they don't encroach any further into that side yard. Isn't that correct?
That's right.
Okay.
And under the ordinance, Mr. Knoxon, the enclosure could encroach the 4 feet. Isn't that correct, or is that, I was confused about?
Not as a porch. If it was just an overhang, like a cantilever, it could.
Okay. I was trying to clarify that in my mind because I'm like, wait a minute, I didn't think that was correct. All right. Are Timothy Hayes and/or Nancy McEldony? Yes. Eldony. Want to come forward, either one or both of you? You've had an opportunity to see the staff report and their recommendation that your request be less than what your request is. You want to speak to that?
We're happy to accept the recommendations of the staff. As you noted, we're not asking for any more coverage. The change that we're proposing to make is simply to place a roof over the entry. So there's no more of anything that is contained. It's just a roof over the entryway as you walk in the front door.
Make it a little prettier.
That would help too.
And I see you have your agent with you. Would you like Ms. Sun to speak to us about anything? Thank you. We have Heidi Sun, 1601 North Fillmore Street.
Yes.
Applicant's agent.
I'm representing the architect's office that was hired to do this design, and I would like to submit that there is a difference between the 4.4 foot and 4.9 foot setback, and I have 3 reasons of why I think this would have a negative impact on the design. First of all, the relationship of the 4th column, which is closest to the south lot line, is the relationship between the location of the column and the location of the roof trim above it is a set, it's a constant, and it has been designed so that the relationship is the same as the porch wraps around the corner. And so therefore, if putting the setback at 5 feet would actually push the column a little bit closer, about 7 inches closer to the middle of where the entry stairs are currently located. That's my reason 1. 2 is there is an existing cornice trim above the foyer, as it stands now in that photograph, and we have designed the new porch roof to have a similar decorative cornice trim that would, I guess, meet the foyer in a way so that it doesn't die into the front foyer wall, but it wraps around ever so slightly and it terminates right at the foyer. And thirdly, the existing porch base, which is going to remain, is at 4.9 feet, and to limit the edge of the roof to 5 feet means that essentially a lot of the water that's going to be falling down from the roof is going to hit the porch floor and splash that area and make it pretty unpleasant when it's raining.
I had one question looking at the drawings and looking at the picture, and I know it's all a matter of angles.
Mm-hmm.
On the drawings, it looks like the proposed column is closer inside the door, in front of the doorway, than the existing column. Is that correct or not?
Are you referring to the 4th column that is closest to the south lot line?
I think, well, the column that we're looking at right here in this picture looks, if you look at your drawing,
right,
looks like it's in further.
On the west elevation.
Yes. It's sort of a bit deceiving because that elevation or that front of the porch is canted on that one side.
Okay.
So it appears to be set in, but it's really as far as it can go.
So it'll be the same location, are you saying, as what the existing column right here is?
In this photograph?
Mm-hmm.
No. We are designing for an additional column to be on the opposite side of the stairs, which maybe if you go to one photograph up, You
Yeah,
see
this
how
one.
the existing front porch is not covered, and the new porch roof would extend over that uncovered portion. There would be an additional column on the other side of the stairs.
Madam Chair,
The picture shows 4 columns.
the photograph shows 4. The drawing, your west elevation shows 3.
It
That,
shows 4, but I'm
well,
thinking.
actually, the photograph has 4. And the fourth one that is showing on the west elevation is with the construction. That's the one that she talked about initially, that if they were required to move it over 5, those additional 7 inches, that column would actually obstruct the door. It would be right in the middle of that. It would be moved over further. That's what that really is. And that's kind of what you were just talking about, that this looks, that actually is the way it looks right if they built it with 4.9, that it would on the face look like that column is in the middle, but the porch is actually at a slight angle like that. And so you're approaching it at a slight angle.
Madam Chairman, can I ask a question? You see the 2 columns in the middle. Are you, on the drawings that we have, you're proposing to go to 1 column in the middle so that there's a total of 4 after the addition?
Correct.
Okay.
I think that's why I was getting confused, because there are 4 here, and I'm like, wait, there's only 4 here. So you're removing one of the center columns. That makes it all much more clear for me. Any further questions? Chair's ready for a motion.
Well, Madam Chair,
You may have a seat, son. Thank you.
I'm not uncomfortable with with what the applicant has sought, and I understand the concerns that staff has. So, but therefore, I don't have a problem, though, with the alternative motion. And I would move that we adopt the alternative resolution for the 4.9-foot setback. And therefore, I move that the Board of Zoning Appeals approve special use permit in case number V-10950-14-UP1, subject to the conditions listed in the alternative resolution.
Madam Chairman,
Mr.
just a
Russell.
point of clarification. You mentioned 4.9, but it is to request
I'm sorry.
permit of 4.4 to cornice and eave and 4.9 to porch base of the right side property line instead of 8 feet is required.
Right.
Then I second it.
Been moved by Mr. Smith, seconded by Mr. Russell, to adopt the alternative resolution. All in favor?
Aye.
Hearing unanimous consent, the motion carries. Thank you.
Our next case tonight is V-10951-14-UP-1. This is a use permit request by Brian O'Connor to permit a setback of 1 foot to the eave and 1.5 feet to the wall of the shed from the rear property line instead of 10 feet as required. This is for the construction of a new 1-story rear detached storage shed. This is in the R5 zoning district on a premises known as 3127 13th Street South.
And the recommendation is to adopt the attached resolution approving the subject use permit with conditions. Okay. Any questions of staff?
Well, Madam Chair, real quickly, if I may, the applicant proposes to do some additions to the house that are by right. And then, you're just looking at the plat, and then build the shed, remove obviously that garage, and then build a shed on that back corner.
Not in this one.
Oh, I'm sorry.
I think you may have another one.
Yeah. 'Cause- 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 'cause-
Yeah, 951.
Slide 16.
16?
Yeah, see, I think that's old.
Yeah, unfortunately, our aerial photos
House and
haven't caught
It's
up.
not the current house, and there's
Google
no
Maps
garage.
still hasn't even caught up yet, so we didn't have any good aerials.
So the changes have already been made to the house?
Yeah,
Okay, all right, and that, so this picture that we're looking at is not
it's
the
useless.
reality
It's
of
useless.
today or yesterday or,
The next one gives us the view.
yeah, okay, gotcha.
Yeah.
All right,
It shows the new siding and the
okay.
actual space we're looking at.
All right.
I guess, Mr. Knoxon, given the 9,000 square feet, is there any other place on the property that this could have been located?
There really isn't anywhere else. This is a corner lot. We have that situation. We're going to see two more after this one where, it's really tough when you have a corner lot. The setbacks are a lot tougher on you, so.
Generally, a 1-foot setback is still pretty close, notwithstanding the normal issues we have on a corner lot. Can I ask why the staff is in favor of this?
We often look at situations where if there's a corner lot and there's an alleyway separating that rear lot line from the next property, which is, in this case, there's a 10-foot alley. So it's just like they have an 11-foot setback from the next property, and that's kind of the way we justify these.
Okay. And with regard to that alleyway, who owns that? Is that? And
Actually, county-owned land.
Okay.
Not sure if you can tell in this picture, but if you look down the left side of the fence, there's another fence back there, and that's one of the neighboring properties.
Right. And I assume the space in between is the 10-foot we're talking about?
Correct.
Thank you, Mr. Knoxon. That's helpful.
Madam Chairman?
Mr. Russell?
Question of staff. If this were an interior lot, would this be able to be placed there as a matter of?
Exactly. 1 foot and 1 foot from side and rear.
Okay.
So the neighbor next door, 44A, could stick one on the other side.
Next
with
to
a
it.
Building permit and not be here.
Is Brian O'Connor present? We may have made your case for you, but anything further you'd like to say?
No, ma'am. Not going to sink my own ship.
You concur in the staff's recommendation?
Yes, ma'am.
Thank you very much. If you've got nothing further, do we have any questions of Mr. O'Connor?
Motion?
Questions? The chair would accept a motion.
I move the Board of Zoning Appeals adopt the attached resolution granting use permit V-10951-14-UP1, subject to the conditions listed in the resolution.
Second.
It's been moved by Ms. Freshman, seconded by Mr. Russell. All in favor?
Aye.
Motion carries unanimously.
Thank you, ma'am.
Thank you.
Okay, the next case is V-10952-14-UP-1. This is a use permit request by Anthony and Sarah Abreu to permit a setback of 1 foot to the eave and 2 feet to the wall of a garage from the rear property line instead of 10 feet as required. It's for a new 1 1/2 story rear detached garage. This is in the R6 zoning district on the premises known as 1732 North Beach Street.
And the recommendation is to adopt the attached resolution approving the subject use permit with conditions. Any questions of staff? As Mr. Knoxon just said, this is another one of the corner lot issues.
Madam Chairman?
Mr. Russell?
Just for the record, the existing block garage shown, is that in basically the same location?
Yes, there's a plat showing here that it is 0.9 feet from the left side yard and 1.2 feet from the rear.
Thank you for your young eyes on that one.
What you say, young eyes?
Glasses don't do much good.
Yeah, that's true. Okay, I believe we have Shyler Ahrens representing the applicant. Anything you want to share with us?
No, ma'am. I affirm the application as previously stated, and I agree with the recommendation from staff. I will just note for the record, I know Andrew Noxon had stated that it's in the same location. We're actually, it's a little bit more further out, actually. We're actually making it better. It will be full 2 feet away from the walls themselves. I think the old plat actually shows less than a foot and less than 2 feet from the actual walls themselves. So we are improving the current condition.
Yeah, it looks like it was 0.9 on one and 1.2, and you're
Correct.
moving it to 2 on both, it looks like, on the
Correct, and then 1
drawings.
foot from the eave, of course, yes. We did get support from the neighbors. I believe the neighbor next door has something very similar in a similar location. As you guys pointed out before, one neighbor in a corner lot subject to something different than an interior lot, and this is one of those scenarios.
And it'll just be a little bit bigger garage to handle the bigger cars.
Correct, correct.
Thank you. No further questions. The chair would entertain a motion.
Madam Chair,
Mr. Smith.
I move that the Board of Zoning Appeals adopt the attached resolution granting use permit V-10952-14-UP1, subject to the conditions listed in the resolution.
Been moved by Mr. Smith, seconded by Ms. Freshman. All in favor?
Aye.
Motion carries unanimously. Thank you.
Thank you, ladies and gentlemen of the board. Thank you.
Okay. Our next case tonight is V-10953-14-UP-2. This is a use permit request by Sue Ann Davis to permit a setback of 1 foot to the garage from the rear property line instead of 10 feet as required, and 3.9 feet from the main building to the new garage instead of 8 feet as required. This is also for a new detached 1-story rear garage. It's also on a corner lot. This is in the R6 zoning district on a premises known as 2400 South Dinwiddie Street.
And again, the recommendation is to adopt the attached resolution approving the subject use permit for a setback of 1 foot to the garage from the rear property line instead of 10 feet as required, and 4 feet from the main building to the new garage instead of 8 feet as required, with conditions. And an alternative resolution has been provided should the BZA wish to grant the use permit for a setback of 3.9 feet between the garage and the main building as requested. So this one's a little bit different than the ones we've seen in that we're not, again, dealing with the 1 foot setback, but here it goes to the larger health and safety question of the distance between the garage, proposed garage and the home. And that is the reason under the zoning ordinance that the setback, there has to be a distance between the main home and the garage to ensure that safety vehicles can enter the property. I think that's been the issue in the past, and I would guess that's why, Mr. Noxon, you are recommending no less than 4 feet. Is that correct? Any questions of staff? But it does appear in this neighborhood, there's been a setback of 3 feet between, but that was, as indicated, that was permitted in error in 2001. But nothing closer.
Madam Chairman, I have a question.
Yes, Mr. Russell.
I'm trying to figure out the two plats. God, one shows a garage 17.8 by 20.3, and the next one, which I get is their proposal, is a 20 by 20 garage?
20 by 20 by 20, it looks like, and it's in green.
There was originally a garage in this location. It was prior to the owner. I believe the owner bought this property in 2012. And right before that time, we had a survey. This is from 2006. We have aerial photos all the way up to about 2011 showing there was a garage in that location. So this is just the last plat we had showing a record of that garage being there.
So it, oh, there it is. So it was torn down already.
Correct. Yeah, you can see it in this aerial. You can tell
Yes,
how
I
out of date these really are.
No, I see it. It's pretty. So, course, there's no distance between the 17.8 wall shown on this old plat to show whether that's where it was before it got torn down or not. It kind of looks similar.
Yeah, it was scaling out to something.
I was getting confused between the two, and I was going to ask the question, why do you want a garage 17.8 feet wide instead of 20, which is standard? And then, yes, it's 20, and so I was getting confused by the two. Thank you.
But it does look like it's pretty close, the old one and the new one.
Mm-hmm. Let me add this too. In terms of the building code will allow structures to be this close to each other, but may require certain kinds of construction materials to deter fire, or those things that under the building code are thought to be, create dangerous situations.
Exactly.
So if making the assumption that that Inspection Services Division would approve a building permit, it seems to me that some of the safety concerns are addressed there. They're not going to give one that doesn't meet the fire code, doesn't meet the other codes. And and there's access down both sides. It's, I just wanted to get that out there. That we're not determining whether it's safe to do this or not necessarily in terms of how close a structure may be to another structure. I know that with particularly commercial buildings, the structures very close to each other can't have windows unless they're a certain distance apart, and that's for fire.
Right, and I was just referring to the fact that one of the issues that we do look at, though, and
Absolutely, no question. That's why I was saying just building code would allow this to be, but requires usually some additional materials that you might not have to have if you had a 25-feet separation. And I'm speaking out of school because I don't know the building code.
No, and I just remember we've had conversations before about whether a fire truck could get in, but usually it goes to your other point, which was what I was going to raise, which is in a lot where there's access from the other side of the building, we generally don't worry about that. I've tended to look at those things more when it's an interior lot and both sides are restricted and there's no access to the back of the property, whereas that's not the case in this proposal.
Point well taken.
Is Suzanne Davis here? Oh, sorry, Sue Ann.
Yes, I am.
Speaking of glasses here, sorry about that.
Okay, there's no Z. Also, I wanted to bring that I did get a letter of support from my next door neighbor, Josh Whitmer.
Thank you, I appreciate that.
Actually, why don't you go to the podium so we can hear? And he's the one next door to where the garage will be built?
Yes, where Josh has no objection at all. The only thing I would ask is if I could please have the 20 by 20 instead of the other, because it's just a teeny tiny little portion of the house, and then it opens right up where the fence is for space, because the 20 by 20 is such a tight two-car garage. And if I give up anything on it, it's going to even make it that much tighter for me, and I really would like to have the biggest 20 by 20 garage I can have for resale value down the road.
Well, I mean, Ms. Freshman and I were just talking about the plot. One of the things you did to ameliorate the distance is you've pulled it closer to the property line. So unlike the prior garage, which appears to have been 2 to 3 feet over from the property line, you are asking for 3 more feet than the original garage was there, but you've moved it over to kind of accommodate that already, too. Any further questions? Okay, thank you. If you have a seat, we'll, I think, provide a motion.
Madam Chairman.
Let's
I
Mr.
was going to make some
Yeah.
statements about the distance is corner to corner rather than much, like a long wall that's only 3 feet wide that you'd walk down. And also, from studying house plans for years and years and years, 20 by 20 is a standard detached or even attached, two-car garage. And so the application is fairly, what's being requested is standard for that. That's why I had the earlier issue about why 17 feet, because that won't quite accommodate two cars. So I mean, you argue to make it even smaller. So with that, I would move the alternative resolution, which is to approve as requested and subject to the conditions in the resolution.
Second.
Been moved by Mr. Russell, seconded by Mr. Smith. All in favor?
Aye.
Carries unanimously.
Okay, the next case is V-10954-14-UP-1, and this is a use permit request by James and Darlene Brown. This is to permit a setback of 11.1 feet to the eave and 11.6 feet to the wall of a new two-story addition and a porch from the left side property line instead of 16 feet as required. Also an aggregate side yard of 18.5 feet instead of 24 feet as required. This is for the construction of a new two-story left side addition with a left side porch. This is in the R10 zoning district on a premises known as 4540 32nd Road North.
And the recommendation is to adopt the attached resolution approving the subject use permit with conditions. Again, if there's any questions of staff. No questions of staff. Are James and/or Darlene Brown present?
Hello?
Okay. Anything you want to share with us, Mr. Brown?
The only thing I want to share was when my wife and I bought the house, it was to keep as much of the house framework as we could. We loved the house. We just wanted to add a second-story addition, and in the course of living there, we found that there was some damage to the front left side of the house that needed to be reconstructed. And in so doing, by taking down the house, we would then be non-compliance with the setbacks, which is why we're asking for the use permit. We've taken our plans and shown them to the rest of our neighbors. We've gotten consent from everybody, and we're really excited about the opportunity to move forward with these plans.
Questions of the applicant?
Madam Chair, this is not a question of the applicant. I'd just simply like to make the observation, as the staff report reflects, that in this R10 zoning district, 80 feet is the width of lots, and 10,000 square feet is the area. This lot is substandard in both categories. It's unusually narrow. It's oddly shaped. And it's substandard in area, and to me, that justifies some relief.
Motion. I move the Board of Zoning Appeals adopt the attached resolution approving the use permit V-10954-14-UP1.
Second.
Been moved by Ms. Freshman, seconded by Mr. Smith. All in favor?
Aye.
Okay, the next case is V-10955-14-UP-1. This is a use permit request by John Rosenbaum, and this is to permit a setback of 1.7 feet to the stairs, 5.5 feet to the eave, 6.3 feet to the wall of the second-story addition and the porch base from the North Cleveland Street right-of-way instead of 25 feet as required, and also 13.4 feet to the eave of the new second-story addition, 15.2 feet to the wall of the basement addition and second-story addition, and 20.7 feet to the areaway from the North Bryan Street right-of-way instead of 25 feet as required. And finally, 5 feet to the hot tub from the right side property line instead of 8 feet as required. This is all for a new second-story addition above the existing home, above an existing front porch, and above a new and including a new left side basement areaway. New front porch and stairway, a new left side basement addition, and to place a hot tub in the right side yard in the R5 zoning district on the premises known as 402 North Cleveland Street.
And the recommendation is to adopt the attached resolution denying the setback of 5.5 feet to the eave and 6.3 feet to the wall of the second-story addition from the North Cleveland Street right-of-way and to the hot tub, but approving use permit for a setback of 1.7 feet to the stairs, 5.3 feet to the porch eave, 6.3 feet to the porch base, and 13.4 feet to the eave of a new second-story addition from the North Cleveland Street right-of-way instead of 25 feet as required, and 13.4 feet to the eave of a new second-story addition, 13.4 feet, I got that right, to the eave of a new second-story addition, 15.2 feet to the wall of the basement addition and the new second-story addition, and 20.7 feet to the areaway from the North Bryan Street right-of-way instead of 25 feet as required with conditions. The BZA has been provided an alternative resolution should we grant the permit as advertised. Okay, any questions of staff? Okay, seeing none at this time. Is John Rosenbaum present?
Yes.
Want to come forward?
Good evening, Board. I actually have some additions to the application.
Mr. Russell, he'll pass them down. Why don't you tell us what you want to share with us
Sure.
this evening?
So what I just shared with the Board there are more clear images of what we're simply trying to preserve here. This hardship that we're dealing with happens to just simply be with the preservation of a significant tree, that catalpa tree, in the backyard. Everything that we want to do with our renovation we could do by right, but it would also involve taking that tree down. And so that tree's location has pushed us forward, and we are trying to keep the integrity of the home, but do the renovation and also keep the vitality of that tree. It's actually, it's been registered with the county for champion status. It's the only catalpa in the county.
And do you know when it was planted or how it came to be here?
Yeah, so I bought the house in '05. I bought it from the family who bought it in '75. They were told by the previous owners of them that that tree was planted in the late '60s, so that it's just shy of 50 years.
Great, thank you. Mr. Knoxon, were you aware of that?
I was not.
Okay, thank you. Anything further, Mr. Rosenbaum?
You've got there is a dozen photos. The first 8 reference the request on the setback exception, and the final 4 photos have to do with the hot tub location. So what we're trying to achieve with the location of the hot tub is, in fact, to reduce the size of our deck, go figure, and gain yard space for a play yard. Right now, as it sits, we're unable to create green space, and we actually want to create more of that. And so the request, in fact, the hot tub request, if you look at the survey, the hot tub would actually be 5.4 feet from the property line, not in fact 5 feet. And with regard to that hot tub, I did have a one-on-one conversation with the neighbor immediately involved with that property line, and within the application there is a signed letter of endorsement for that location of the tub, provided there were no other issues.
Madam Chair, I have one brief question of the applicant. I didn't hear exactly what you said with respect to a tree champion, but I'm looking at your submission just now with the photographs and the page from what appears to be some kind of a publication that
That's right.
describes Arlington's urban forest and big tree, and it says on the bottom, "Got a champion?" ? Arlington needs champions for the following native species, and common catalpa is listed as one of those that's in need. So have you sought the designation of a tree champion?
In fact, I have. If you go to page 5 of the packet I just handed you, there's a confirmation email from the forestry supervisor.
Oh, okay. All right. I hadn't gone to that yet. Thank you.
Sure.
And that's the reason you don't want to put the hot tub in the location the staff is recommending, is that correct?
So actually, the request on the table is twofold. Is one for the location of the front porch encroachment, which is directly related to the tree. The tub location has to do with having a yard for a swing set. And the tub location is going to be 5.4 off the property line, not 5 feet.
Mm-hmm. And Mr. Knoxon, the staff has approved the permit for the porch, correct?
For the porch, our issue is more for A, the hot tub, B, the second-story addition above the front porch, which would bring it very close to the street. Our recommendation was to knock that back to at least the point where the existing wall is between, the first floor and that front porch.
Mm-hmm. Mr. Rosenbaum, what's your comment directly to the staff's recommendation?
Precedent in the neighborhood has been established with encroaching closed-in second stories over the front porches. We could do precisely what staff has recommended, but we then lose the tree. We're really in a bind with which way we go. We're hopeful that the board obviously sees the value in preserving.
Explain to me how you lose the tree. Isn't the tree in the backyard?
So if you look at that's why I more specified those color photos I just handed out. If you notice the orientation of where the stump is for that tree, that would be precisely where a footer would need to go to get the support for that second floor to come back that direction. So the plans are to have mimicking columns that would repeat the front 3 columns, but in the backyard. We could do that 3 fold column on the back as well, but the column that we have removed from our proposal is precisely where the catalpa tree exists.
So your point is you would move it back, you wouldn't just cut off the part that's over the porch in your design?
Correct. In fact, if you go to the second floor plan proposal, it would eliminate any value of the renovation. It would take a 10 by 11 bedroom and make it roughly 5 by 11 or thereabouts.
You can have a seat. I think we're going to be ready to deliberate. I don't think we have any more questions right now. Thoughts? I guess, Mr. Knoxon, one of the things that I find interesting with the drawings and the proposal is sort of a contrasting, this isn't really the kind of enclosure we would normally see over a front porch. And it's not quite a cantilever, which oftentimes we see over a front porch where a new addition is brought out. But the intent of it is more along the lines of a cantilever pulling out the front of the house to accommodate more space. So I was wondering if the staff had thought about sort of the difference. It's not the typical enclosing a front porch. It's really pulling forward a structure in front of the house. And would it have made a difference if they had done a cantilever design on the house?
I think so. I mean, if you're going to have a 7 to 8 foot cantilever, it's really going to throw off the design of the house. I mean, you still have a second story, 30-foot high roof, 8 feet from the property line. So.
Madam Chair, might I ask the applicant just briefly, I know that the report reflects that you've made some contact with neighbors and, I say, kind of a series of responses. I've read the responses by your neighbors. I'm wondering if they understand how tall this is. It's not a height issue, but it is, I think Mr. Knoxon kind of defined one of the issues is how close something that tall is to the lot line. And I do agree with the chair with respect to the front bedrooms not being a lot of mass over the porch, but the peak of the roof. It's not well. It's a big, tasteful, very tastefully designed. I think it's tall. And I was looking at the space, the interior, and there are some large dimensions for some of the rooms. I wouldn't advocate making the 2 bedrooms in the front very small, but there are large dimensions for the whole master half of the upstairs. The extremely large, and I know her dressing room is much bigger than his. There's a lot of space in. So there could be some crunching.
So if I may actually speak to that, there's a couple of points I'd like to make. On page 2 of those photos, pictures number 7 and number 8, if you look closely, you'll see there's actually a level that I have set on the shingle, which would effectively orientate where the wall is proposed to go, so as far as sight lines. So that is a clear representation of what the encumbrance would be. Now, as far as reworking the layout of that second floor plan, the one binding factor that we're dealing with is the existing bump out to the south side of the house, which is going to embody the new staircase. Right. And so what you're talking about would require a substantial rewrite to the entire plan relative to how the stairs work into that.
I would leave that alone. It would be more in the area of the, what I was describing, the master bedroom area from, and you've got a utility room up there. I presume you're not going to have a second one in the basement, but I thought I saw something about utilities in the basement also. I'm not suggesting a complete but there's that office kind of, the basement. There are some large dimensions on that. I think it's tasteful, but...
Well, I appreciate that. And as far as the largeness of it, certainly the percentage of lot coverage is well within the
No, I'm talking
allowance.
about the size of the... because you say you can't go back. I'm with you. I don't want to touch anything on the backside. Any more than, because of the tree. I think the tree is something that is valuable and has to be preserved. And so how do you make up space? I think that if, building to the edge of the envelope, and then going and asking, and yes, it's a 1924 structure, and you've got some, historic issues with respect to the front. That's your 7 and 8 pictures with the level on the roof are helpful. And those are, it's not a complete vertical wall on the front. That's obviously very helpful, but that keeps it in taste with the neighborhood. It's just large on the inside. The dimensions are large, and mostly in the master bedroom area, the master suite area. That's where it's really large.
Madam Chairman.
Mr. Russell.
I have a couple of questions. Mr. Knoxon, if this house was encroaching, if it was not a porch and the house was encroaching, one could go straight up as a matter of right, correct?
That's correct.
And I'd like to see the aerial photograph again, Cheryl, if we could, please. So this row of houses, it looked like it on the materials provided is they're sort of all similarly set back, or at least the three that we can see. There's a couple more.
In fact, the
to
entire
right.
west side of Cleveland Street is, all of the setbacks are nearly identical, if not
But two porches.
porches.
Yeah, two porches. So the porch is being maintained. It's the question is building over a porch.
Correct.
And so the side where the staircase is could be built as a matter of right as well. There's no use permit request for that. It's just the issue of the porch.
The lower left-hand corner of that aerial view there is actually 312 and 320 North Bryan Street, which both are existing conditions for what we're asking, with a closed-in second floor over an encroaching front porch.
Well, I talked myself into it now. I was talking to I was listening, and that's and this actually this picture is more helpful.
I'm all for saving the tree. I do think that a second story over the porch will make this house massive. And I agree with Mr. Smith that a lot of the dimensions for the master suite are beyond generous. So I'm not inclined to support the request, because I just think that there are other ways to do it, and I think that it is having a complete second story over that porch is not appropriate.
Mr. Russell?
I'm not sure that the size of the house bothers me that much, in the sense that in the neighborhood there's been new construction, whether by right or by some grant from this body I'm not aware of. There are houses that have been of this style and the other styles there that have added second floors. I guess I sort of don't have a problem with the second story over an existing porch where everything down the street is lined up at that same distance. I'd be in a different place if the other houses were set back another 10 feet, or not even back to 25, but that it wasn't in line. So I don't have that much trouble with the second story. I think the tree is compelling. However, I think the tree can be saved with a different design of house too. So, I'm not sure. I'm not sure I buy that. So that and I don't think we can make a determination based on that. In the sense that if we don't prove it, the tree's coming down. That's sort of not ours to make. I certainly hope the tree doesn't come down or have to. There are different designs, But I mean, my point is I don't have that much of a problem of the second story over the porch, which seems to be the question.
Well, I think there's a couple of questions. There's that and the hot tub, which we've not spoken to. But I actually am leaning more towards where Ms. Freshman is, which Mr. Rosenbaum would put you in a difficult position, because we only have 4 board members here this evening. And if we do render a 2-2 vote, which is sort of where you hear inclination from the board, then that would not, that would result in a denial of your application. Oftentimes when we're in this circumstance, we offer the applicant an opportunity to go back and see if there's another alternative to a straight-up denial, and that way you preserve your filing fees and everything you've paid already before we actually make a decision on the case. And or if the other board member were here, you might get a different result if you have 5 board members present. So that's one thing I throw to you. Before we do that, though, I think would be helpful if we got a sense from the board, at least at this point where we are with regard to the hot tub. I think personally, even though the existing homeowner says it's not a problem to have it that close, my personal experience on the board and with the community is that that's only going to lead to problems down the road if it's that close to the neighbor's yard. We've heard of drainage problems and other issues that emerge, and so I'm inclined to follow the staff's recommendation on that issue as well, at least if I were to vote tonight.
I'd be curious to hear your position on the turning down the setback on that front porch, if you would share.
I said I'm in line with Ms. Freshman. I think that the mass of the addition, and I think the size of the rooms could be either modified or another design as well could be done. And some of the factors that I look at is there something else that could be done before granting this use permit in that would be more
Naturally.
reasonable?
So I actually had given some consideration to this idea before coming to this evening's meeting and wondering if the front setback, instead of it being sit on the columns, would there be a concession of a receding back a little bit and having a little bit more of a flare that would effectively pull that wall back about 18 inches. And then I can work within the framework that I've currently got. I'm able to reduce those front room sizes and keep the footprint as proposed.
Or just or reduce your master a little bit and keep your children's rooms larger.
Perhaps so, but
That all speaks to a deferral. That speaks to a deferral. You can't redesign it standing there.
I think the only problem would be with that is that we would need to see the actual drawings and recommendations before we could vote on it.
Mhm.
So it would be in line, as Ms. Freshman just indicated, with a request for a deferral, in which
Yep.
case we would hold this until you have a chance to redesign that recommendation. I know the staff is always willing to work with people as well to help you have the best opportunity to come forward with a proposal that can be hopefully given their positive recommendation.
yeah.
And Madam Chair, I have not thought much about the placement of the hot tub yet. That's where that new concrete slab you propose is.
And Mr. Knoxon, there's no lot coverage issues with any of this?
No, not at all.
So maybe I don't know if anybody else is in a position to say anything about the hot tub to give direction to the applicant, and if not, we can hold that till we next hear the case. Oftentimes, Ms. Rosenbaum, it also is helpful if there's part of the addition that's being done by right, just for our purposes, to be able to see that in a different color on your drawings or something.
I'm
Sometimes,
sorry?
as Mr. Russell pointed out, the side where the stairway is can be done by right, and you're not requesting a permit by that. But if we see all of that together as the whole rebuild is designed.
I didn't present it that way.
Okay. Oh, you're not doing anything to that side?
The southern bump out that has that 10 by 10 space was part of the corner lot allowance back in the 20s when these houses were built, that they had those bump outs. So that was done back in 1924.
But you're not putting a stairway there?
I would be putting a stairway in there, but I believe that would be done by right.
Right, and that's what I'm saying.
And
is
so I had applied for that by right. I did not ask for that to be a part of the conversation.
No, what I'm saying is what's helpful for us sometimes is to see what the rest of the design looks like, including what you can do by right, because that gives us the better picture. So what you've presented today is only the part you need the actual variance for, but I'm sure as you're designing the project, you've considered both the by right part and the other part.
Sure.
And so for us to see how that fits together when we're making an adjudication, sometimes it's very helpful. That was my only point.
Got it.
And then designating that in a different color to say, I don't need your permission on that, but this is how the whole design fits together, is sometimes visually very helpful for us.
And just for the record, that areaway is not by right. You'd have to be at 21 feet to be by right. And same with the front stairway. We've added those to your request on the front page of the staff report, just for that purpose. And the existing stairway is closer than 5 feet to begin with, so We added that to bring it into compliance.
I wasn't sure about that. So staff was looking out for you, and they actually have added that
Got it.
here. And that's why, again, mentally, you may not have been thinking about that, but that's why a redesign might be helpful. So I think at this point,
And one more, now I have given some thought to the hot tub. Why not in the rear? And you wouldn't have to remove the tree to put a hot tub.
No. The hot tub is irrelevant to the tree concern.
it's for swing set.
It's the location, and there's no backyard. We have a detached garage and the location of the tub, and we're trying to shrink our deck down to roughly half of what it is so that we can get some sod in there, and the hot tub is right in that space.
Swing sets are temporal. They quickly grow out of swing sets.
Well, lime down for a football field.
Yeah, or soccer.
Okay, I think the chair's ready for a motion.
Well, what would be an appropriate length of time?
How long would you need, Mr. Rosenbaum, to redesign and produce the new drawing? 1 month, 2 months? What do you
Well, I
think?
believe at this point, coming into the holidays, are you guys, how does that play
January
into?
would probably be the next best time.
We don't have a January meeting, not until February.
February.
December or February, probably not enough time.
And even for December, you have about a week and a half to get revised drawings in.
Could that be a tentative request?
It's possible. I mean, I don't think you're going to have to do too much to the plat. At least we'll have something to advertise setbacks with. But we do have a very large agenda that month, too, so.
It'll be a very long night.
Another one?
Well, that also assumes that he wants to come before the full board with a redesign.
Well, if he doesn't need a redesign, I mean, he indicated he was willing to do a deferral because he wanted new drawings. I mean, he was willing to put an 18-foot difference, but as Ms. Freshman points out, 18 inch, we can't vote on that because we don't see it.
Right.
So
That's right. That's right.
that's why we were proceeding on the deferral route, Mr. Russell.
We have a fourth board member who's tentative at this point anyway, Monica Craven, so.
Tentative for next month, or? No, not if Monica's not here.
Pardon me, I didn't understand this point. Is she saying she's not coming next month?
She hasn't given me an actual answer on if she's going to be present or not next month, so.
I couldn't
Exactly.
quite hear what the comment was.
Or in the future, sorry. Yeah. So we're looking at February as the best bet. But, I mean, we could do till December, and obviously, if you can't get the drawings in, we can make a motion to defer till the February board meeting and at the beginning of the December board meeting if you can't make
So
it.
if I'm not mistaken, I still have the option to go a totally different route and not even request the permission of the board?
Exactly.
Okay.
Yeah. But what we're trying to do is save you the filing fee in case you
Naturally.
decide to come back, then you might as well still go on the application fee that you've already paid.
Understood.
So December or February?
I'd like to, if I could say for now, I'd like to say December, and then if in the next couple of days I'm unable to really feel comfortable about that, I can be in communication with Drew and suggest February.
That would work well. So, Ms. Freshman?
I'll move that V-10955-14-UP1 be deferred to the December 2014,
10th, isn't it, Mr.?
December 10th.
December 10th, 2014, Board of Zoning Appeals meeting.
Second.
It's been moved and seconded. All in favor?
Aye.
We'll see you back next month or in February.
Hopefully the sooner. Thank you.
Thank you.
Or never if you find another design.
Okay.
Okay.
Next case is V-10956-14-UP-2, and this is a use permit request by Nathan and Francesca Guerrero to permit a setback of 6.1 feet to the new two-story rear addition from the right side property line instead of 8 feet as required 8.9 feet to the porch from the left side property line instead of 10 feet is required, and also an aggregate side yard of 15 feet instead of 18 feet is required. It's for a new 2-story rear addition and a left side porch. This is in the R6 zoning district on the premises known as 207 North Oakland Street.
And the recommendation is to attach the adopt resolution approving the use permit with conditions. I know. Any questions? No, seeing no questions of staff, are Nathan and/or Francesca Guerrero present?
Yes, good evening. I'm Nathan Guerrero. My wife, Francesca, is in the back room with our new baby, who we brought tonight. I think our application and our proposed addition is pretty straightforward, so I won't take up a lot of time about it. I just want to thank the staff for working with us and thank the board for your consideration, and I'll entertain any questions you may have.
I mean, for the record, your request is in line with other actions that have been granted in your neighborhood, so this would be consistent with the designs in the neighborhood. We appreciate that you chose something that would be compatible.
Yes, we were very cognizant of the character of our neighborhood, and so we made a point of keeping our addition sort of set in the back of the house, so the front of the house is maintained. As you can see, a lot of our neighbors have additions off the back of their houses that are similar, so I think it is very consistent, and our immediate neighbors were all supportive, as I think is reflected.
It was an excellent packet. Appreciate your time and effort in putting that together. Thank you.
Thank you.
I'm going to wait until Mr. Smith comes back because I know he's read the report. And if he has any questions, I'd rather have 4 of us here present, just in case. We were waiting for you.
Oh, is this Mr. Guerrero?
Mm-hmm.
Yes.
Madam Chair, I find that's a substandard size lot.
Mm-hmm.
And in width, Mr. Russell's comments earlier about if this were a standard size lot, 60 feet, you would have far less of an issue with respect to the side yard setbacks that he's seeking. It wouldn't be exact, but it would be a lot. You'd have 10 more feet.
But, and it is in line with the existing structure of the house. Isn't that
Yes,
correct?
that's correct.
So it's not a circumstance where he's amassing or going wider in the back. No further questions? The chair would entertain a motion.
I'll move the Board of Zoning Appeals adopt the attached resolution approving the use permit V-10956-14-UP2, subject to the conditions.
Moved by Ms. Freshman, seconded by Mr. Smith. All in favor? Aye. Carries unanimously. Thank you.
Thank you very much.
Can I just make a quick point that I might ask Drew to do in future reports? If we could, if just as part of, say, the information at the top or somewhere in the report, note what year the house was constructed. This is another one where the side yards don't match. The lot was apparently platted before the 1950 ordinance, and one of the things you learn about the 1950 ordinance, it almost made everything in the county that had already been built non-conforming, and that's why we have so many of these cases.
We have the date in here. It was 1939. It's kind of tucked in the second page in the very top right corner where you can't see it.
I see. Thank you. That was the one word in the report I didn't read.
I was going to say, I thought I saw the year on here.
I think it was the position of the staple. Blame it on that.
There you go.
Okay. Next case, Mr. Noxon.
Okay, next case is V-10957-14-UP-1. This is a use permit request by Eric Johnson. This is to permit a setback of 5.4 feet to the eave and 5.6 feet to the wall of a new one-story addition, as well as 2 porches from the left side property line instead of 10 feet as required. Also 6 feet to the chimney, 7.8 feet to the wall of a new 2-story addition from the right side property line instead of 8 feet as required. Finally, an aggregate side yard of 11.4 feet instead of 18 feet as required. This is all for the construction of a new 2-story rear addition with the chimney, 1-story left side addition, left side screen porch, and also a rear porch. This is in the R6 zoning district on a premises known as 1914 North Madison Street.
And the recommendation is to adopt the attached resolution approving the use permit with conditions. Any questions of staff? And again, Mr. Knox, I take it that the neighborhood and small side yards are all, again, as a result of the original placement of the houses?
Correct.
That's what it looks like on the map. No questions of staff. Is Eric Johnson present?
Yes.
Good evening, Mr. Johnson.
Yes, thanks. Nice to be here.
You have anything you want to say to us?
No, I concur with the staff's recommendations, and I'm here to answer any questions you have.
Questions for Mr. Johnson?
Are you the architect also?
That is correct.
Okay.
Okay, ready for resolution?
I move the Board of Zoning Appeals adopt the attached resolution approving the use permit V-10957-14-UP1, subject to the conditions.
Second.
It's been moved by Ms. Freshman, seconded by Mr. Russell. All in favor?
Aye.
Motion carries 4-0.
Thank you.
Okay, the next case is V-10958-14-UP-1. This is a use permit request by Teresa Pilkerton and Clyde Fortna. Permit a setback of 20.8 feet to the stoop, 18.8 feet to the eave of the home, and 19.4 feet to the wall of the new home from the North Abingdon Street right-of-way instead of 25 feet as required. Also to permit a building exceeding 2.5 stories within 25 feet of a street right-of-way. It's for a new 3-story single-family home with a covered front stoop. It's in the R5 zoning district on a premises known as 4703 Wilson Boulevard.
The recommendation is to adopt the attached resolution approving the use permit with conditions.
Madam Chair,
Yes, Mr. Smith.
might I ask staff if they find it unusual to see disclosure statements notarized by out-of-state notaries? Is that common?
We see it every once in a while, especially since a lot of the local architects or contractors or owners, property owners are from Maryland, D.C., Virginia, so we see them here and there.
We've seen 2 tonight from Delaware. That was the...
Interesting.
Are Teresa Pilkerton or Clyde Fortuna present? Mr. Fortuna, you want to come forward? Okay. Do you want to tell us anything else about your project?
Well, we have growing children, so we were looking to get bedrooms on the upper level. The Delaware notary we were at the beach at the time, so.
So that may explain it,
looked
Mr.
up
Smith. People are at the beach.
Local notary
beach,
there
of
rather
course.
than-
And Virginia doesn't have any good beaches?
Oh,
Assateague?
Virginia Beach.
Virginia Beach.
Prefer
Yeah,
a little
just-
further down the
just-
Delmarva
just-
personally.
Just 3 hours away.
Too many jets flying over it.
Depending on traffic, Virginia Beach is only 3.5.
I think that's
4.
beside the point. I have a question of the applicant or the staff. One of the things that struck me about this is, and this picture may help a lot, this lot is undulating, isn't it? Because it appears you could basically walk out of the second floor onto land on the back of the proposal, but on the front, you're right much above the street level with
Yeah,
the plan.
there's a sloping hill all the way down
Mhm.
the corner, and when we built the
I
wall
see.
originally, it leveled off, but
Mhm.
the slope continues down.
Yeah, I mean,
From
the-
well,
at
it's
first,
angular, it comes down to the corner from.
at first glance, looking at the plans, one looks at it and it's a request to be more than 2.5 stories, which I understand that, which is separate from how tall it is, but it looks very tall with the many steps. And first thing that came to mind was, can't they lower the basement into the ground? But then it further and looking at the site, it's higher in the back than it is in the front. So that makes it difficult because then you'd have to step up within the house. And that was just an observation.
Any additional questions? See a lot. So there'll be no garage as part of this? Will you have a garage?
I think we have the design, I have the designer here.
Yes, there's a garage at the rear.
Did you provide a speaker slip for me, sir?
Sure. I'm listed as the agent on the...
I know. We still need a speaker slip. And the only reason I asked Mr. Noxon about the garage is when I look at the lot coverage, and this was triggered by the fact that it looks like they have a breezeway or a covered something adjoining to a garage, and recent months we've had discussions about what the impact of joining the garage to the house by such a breezeway would be on lot coverage, and it's not calculated into the lot coverage sheet that we have.
That's right.
It says 0 for a garage, and I'm just...
No, that it should be calculated in there. Let me tell you what I have here.
Yeah, I have 0 for the square feet for the detached garage or detached building.
Okay, so total lot coverage, I am getting 35.8%. And they would be allowed actually 45% totally.
Well, interestingly, the calculation sheet that we have in our packet says 44%, and it still has 0 for the garage.
That one there.
That's the max.
It looks like it's over 300 square feet, too. 10, 250, 6, 200, roughly 200.
I'm trying to see if they actually calculated into the main building as opposed to a detached garage. Because I remember there was some back and forth with us when they were first designing this on
The main
that
building,
connection.
the main building only is 1753. I wouldn't think that that would include a garage.
1753.
I believe that we did calculate the garage because it was attached by the breezeway, because the footprint of the house itself is 1,200, roughly.
Okay, so the footprint is
slightly over
12.
1,200.
Okay, and did you add the breezeway as well in the calculation?
Right, and the patio as well.
Okay, and that was the reason I was asking, is because when we see the lot coverage issues, when the breezeways are there, exactly what you said, that would become part of the main residence?
Right,
Okay,
exactly.
so I appreciate that. And you are Mark O'Grady?
Yes.
2279 Millstead Drive, Ashburn, Virginia.
Yes.
And you're the agent for the applicant, is that correct?
Yes.
Now that we have the agent present, we've answered the lot coverage. So is the 44% lot coverage that's in the application what you would calculate the lot coverage to
Right,
be?
that's total. That includes the driveway as well.
Okay, so that's why there's a difference between what Mr. Noxon had and, because you were saying 38, 37?
I have 35.8 total.
I knew there was an 8 in there somewhere.
Getting 2,383 square feet total lot coverage. And the patio actually wasn't counted into that because it's at grade.
So, Mr. O'Grady, do you want to tell us anything more about this proposal? Or maybe talk about the topography and the height, the 2.5 stories as well? Both of those are issues that we have in our packet.
The top floor of the new home is built under the roof structure, or within the roof structure to minimize the overall height versus that being a full height from the elevation. So it's built into the roof structure with shed dormers. So we did that to minimize the scale of the project, to also gain the amount of space they needed, because we needed to go up rather than out because of the shape and size of the lot and the setbacks due to the corner.
Questions?
Comment, Madam Chairman. It seems to me that this design on a corner lot has chosen to use height, still meeting, I presume, the 35-foot height limit, but comes afoul or runs afoul of the 2.5-story requirement, rather than designing something that encroaches more into the two setbacks that many people on corner lots have to deal with, 25 feet. And so these are at 20, 16.4. They're less than a lot of our requests, and no real relief, unless I'm reading something wrong, on the front requested. A comment.
Yeah, let me ask, and the other thing I see is you're actually moving the property over from the existing line, which was originally 6.3, and you're moving it to 8, except with the chimney. Is that correct?
Right, exactly. So when we remove the existing house, the new setback is 8 feet. So we're meeting that on the side, also on the front of 25. We're meeting the setback everywhere except that front corner.
In the front corner.
And because the lot narrows at the front at Wilson, if it were to continue straight, if Abingdon were parallel to the property line, we wouldn't even need this.
It is going to be a pretty tall building on that street, isn't it?
Well, I think it's relative. But we've done things to reduce the scale, rather than it just being a tall rectangular structure with offsets in the roof structure.
And this is the front or what we're seeing on the picture? Is the rear, right?
Side and rear.
That's the side and the rear.
Side and the rear.
That's looking from Abingdon.
Abingdon Street.
Okay. If there are no more questions, the chair will accept a motion.
I move the Board of Zoning Appeals adopt the attached resolution approving the use permit V-10958-14-UP1, subject to the conditions.
Second.
It's been moved by Ms. Freshman, seconded by Mr. Smith. All in favor? Aye. Motion carries 4-0. Thank you very much.
Thank you.
Thank you.
Okay, the next case tonight is V-10959-14-UP-1, and this is a use permit request by Helena and Paul Peck to permit a setback of 13.1 feet and also 14.7 feet to the two planter boxes, 15 feet to the right side stoop, 16.2 feet to the window wells, 17 feet to the eave, 18 feet to the wall of the new home, the front porch, and the rear screen porch, all from the 14th Street North right-of-way, instead of 25 feet as required. This is for the construction of a new 2-story single-family home with a right side covered stoop, a front porch, rear screen porch, right side egress window well. This is in the R6 zoning district on a premises known as 1318 North Abingdon Street.
The recommendation is to adopt the attached resolution to deny the use permit, and an alternative resolution has been provided should the BZA wish to grant the use permit. Start, as always, with questions to staff.
Could you just make an observation that this is not a lot with a hardship in terms of what we've talked about with width and square footage, and given that it's a new construction where lots of choices can be made, doesn't have the same constraints as modifications that we typically see for us.
Okay, are Helena or Paul Peck present? Both are present for the record. Do you want to speak to the staff's recommendation or your request?
Yes, please.
Feel free.
My name is Paul Peck, and I'm here with my wife Helena and our builder, as well as neighbor Dave Springberg. We are 20-year Arlington residents, including 16-year homeowners at 1318 North Abingdon. We're here tonight seeking a use permit for construction of our new home on our existing lot. I would first like to thank the zoning board as well as staff for considering our use case permit. We have lived in our home as originally constructed. As I said, for the past 16 years, we've raised our 3 girls in that house. They're now 15, 13, and 11. We love our lot. We love our neighbors, as well as the ability for our kids to walk to Swanson and W&L, where they all attend school. We're also very involved in our community. I think if you ask my wife, she would say we've even worked very hard as part of the neighborhood conservation funds to take advantage of the streetlight program. In fact, maybe you see them in some of the pictures, but were installed just this past summer. So we care about the beautification and the look of our neighborhood as well. We're really seeking to rebuild our home for a couple of reasons. First, with 3 girls, we've simply outgrown our home, the original Cape Cod style house that's been built. We also have persistent foundation problems and significant water leakage every time we get a hard rain. And third, we're seeking to have a new home that's going to meet our needs to be able to stay, on our lot for the rest of our lives as we age. My wife 6 years ago broke her neck. We've had problems that we've dealt with that. We're looking forward to make sure that we have a floor plan that meets our needs as we age. We are seeking a use permit that does meet front, left, and rear setbacks. We are requesting a a right side street setback variance. As longtime residents, we have worked very hard to make a home that's compatible with our neighborhood, including hiring a well-respected architect to help us get it right to conform to our neighborhood, designing a Cape Cod-style home, which you'll see in the architecture drawings, which are prevalent to our neighborhood. We have worked literally for months to try to get the side and right elevations correct, including, as you'll see in the diagrams, designing a gradual sloping roof that's less imposing from the front and right side elevations. We also designed a home that has a significantly smaller second-story footprint to better blend into the neighborhood, and the height of the home we're proposing is 26 feet. We really got to this point, and I think as staff mentioned, one of our options is a buy right option. We do believe the buy right option would actually be less compatible with our neighborhood and essentially force us to create a taller, much more box-like home that just simply wouldn't fit in to the neighborhood. A couple of other key points. Our proposed new home would actually narrow the width of our existing core structure from 42 feet to 35 feet. Today, as originally constructed, our home is 4.4 feet off our left property line and 15.3 feet off 14th Street. We're proposing a structure that would be compliant 8 feet from the left property line and 18 feet from the main structure from 14th Street. Really, from a practical matter, we're moving 3.5 feet farther away from our neighbor to the left and moving 3 feet farther away from Abington from where our current porch sits today. We do think we have a little bit of a unique situation with the corner lot that we have. We have no other neighbors west of us on 14th and Abington. We're an entrance to a park. Really, if you see in the other photos, the park entrance is right there, so there's no neighbors on either side of us on the side of the variance request that we're making. So the street itself is a dead end. The only purpose of the street is to enter the park as well as to enter the driveways of us and our neighbor across from us. I think also, as mentioned earlier this evening, there has been a precedent established in our neighborhood, and it's also mentioned in staff's report. There's a house, 5 houses up from us on a corner lot in one direction, and 5 houses the other way from us on the other corner lot, both on the same side of the street, that have also been received approval for a greater side street setbacks than we've requested on much taller homes. The house at 1206 North Abington has a approved 14-foot side street setback. At 1502 on the corner, 5 houses north of us has 15-foot side street setback approved. So what we're requesting, is the 35-foot wide home, with 18-foot setback from the main building. I guess I would just add, the last is that we have included 8 letters of recommendation from our neighbors. I guess if I included Dave Springberg, our builder, again, it's also a neighbor. We technically have 9, but Dave could speak to that if he disagrees. I'll just leave it at that. In closing, we do love our neighborhood and have taken careful attention to make a home that we believe would be compatible with the neighborhood. We respectfully ask that the board approve our use permit, and I'm happy to answer any questions that you may have.
Questions? Freshman? Okay, thank you. I believe we do have a speaker slip from your, is it architect or builder? Or neighbor? I don't know. He's checked.
I'm a little bit of everything.
Individual. David Springberg, 1400 North
Buchanan Street. I am a neighbor on the other side of the park. I am their general contractor, and I have been assisting the PECs to coordinate with their site engineer, R.C. Fields, and their architect, Tom French. Tom French is at a funeral this evening and couldn't attend, so I'm here to answer questions regarding...
This packet we got this evening?
Yes.
Is this house, okay.
Exactly, that is the house, and I can specifically discuss siding of the house, those pesky planter boxes that are required everywhere, as are most of the encumbrances, and anything else. So I'm here.
And I guess that was my question, the planter boxes. I know I've heard and I read that they were necessary for drainage, but they do seem to be encroaching into those setbacks, which is sort of a concern. And to Ms. Freshman's point, there are often alternatives when you're building from scratch. So,
yes.
And even to Mr. Peck's point that you're building a narrower house, you're effectively extending it again then by putting in those planter boxes.
Yeah, I
Can you talk about
address
that?
that. Yeah, those planter boxes are shown. They're planter boxes of last resort, and we're hoping that they won't exist. We have to treat roughly 75% of the roof with any new home. It requires basically planter boxes of some sort or infiltration trenches. Our first choice was to install an infiltration trench along the rear of the property, because that's the natural flow of the topography of the land. We had borings done, and they were not sufficient to support draining the water, infiltrating it into the ground. So option 2 is planter boxes in the ground in the location shown on the site plan, and tie them underground into the storm drain on 14th Street. That is the hope and plan. But we're kind of sort of in this chicken-egg situation where we can't get approval from DES to do that until we do a full engineering plan, which we can't do until we know yes or no regarding the status of the house. But the hope is that they're going to stay in those current locations and be flush with the ground, and then the under drains will be able to tie into the storm drain in 14th Street.
So it says flush with the ground, but on the drawings, they show that they're pretty
Right now,
tall.
generally, I don't know if you're familiar with these boxes or not, but generally they're intended to pool a little bit of the first half-inch on top and then filter through, and there's a series of stone and different types of media. And then on the other end, it's supposed to drain out. You have to have natural topography in order for it to drain out. So
these are replacing what we know as French drains in the old days, or sort of.
We've called them rain gardens, or I mean, at some point the water has to go somewhere. And the idea with the infiltration trench in the rear of the property, which was our first hope, was that the water would drain to the back of the property and then infiltrate into the ground.
Mm-hmm.
But if not, it has to have a place to run off somewhere. Mm-hmm. So if we had these boxes in the ground, then there's still a plastic pipe at the bottom, a 4-inch outlet of it, that we would tie underground into the storm drain into 14th Street. And we expect that DES will allow us, but since we were coming here, we wanted to be prepared in the event that DES had a reason not to allow us to tie the stormwater into the drain.
And what about setting a storm drain or another drain that would, something like a drain on the property? Is that considered instead of something that would widen the width of the?
Well, there seem to be 3 ways to address stormwater right now. One, is the infiltration trench, which we don't have the soils to support. The second would be a bioretention pond, which would be the same thing, basically a mulch pit in the ground. But again, you have to be able to get the water to flow to it, and then again, it has to be able to it has to drain somewhere. So the under drain would have to tie into the storm drain into the street.
So on the front design, I'm not seeing where the gutters tie into these boxes. Do the gutters tie into the boxes?
The gutters, they're basically, if you pick the 4 corners of the house, I don't have the pictures here in front of me, but we had to treat 3 of the 4 corners. So we picked the 3 corners that were closest to the roads to get to the storm drains. And the way the roof flows, that it'd be the front left and right corners and the back rear corner of the porch, is where the downspouts would come down into these boxes, and then from the boxes, hopefully, into the storm drain in the road. But the boxes would then be flat. But you still have to treat the water that comes off the roof, both combination of detention and clarity. So
that's very helpful. It's just hard to visualize them underground when they're
if you can picture them disappearing, going flat, they have to have a way out, and it's about 42 inches of media that the water has to be able to pond and filter through, and then have a way out.
Okay.
And that's why you see them everywhere. we've tried to find some very creative. I built a house recently on Buchanan Street, which is the other side of the park, where we were able to pond it in the front and then come down the street and tie into a catch basin in the road. So the county lets us do it quite a bit, and it's an innovative way of doing it. Especially since July 2nd, when the new Chesapeake Bay Ordinance went into effect, we've had become even more and more creative about finding ways to deal with it. So.
Thank you, that was very helpful. Any additional questions?
Madam Chair, I was trying to think through how to craft a motion that would encourage the applicant to accomplish the placement of the retention, the storm drain retention ponds or the settlement tanks, if you will, below the surface, if possible. And I don't know that we can say give it your best effort.
That's our wish. That's our wish to put them below grade. So we are going to do everything possible. It's just.
Okay, actually, we need you to stay, if you're going to speak, you need to speak into
That's
the.
our desire, would be to have them below grade. It's just until we can find out if they'll allow us to put them there is really the question. Yes.
And as I understand it, it's a catch-22 because it's a huge waste of money to go to full engineering drawings on a plan that might have to come back to us for something.
Correct. That's exactly why we held off.
Our initial conversations were with Chen Chen Ma at Chen Chen, can't think of her last name, at DES, and we sort of got a verbal yes, this will probably work, but nobody will commit to anything until we submit the full 9-page engineering plan.
And I just want to second what my husband said. We really tried to make the house fit in with making it a Cape Cod, and tried to have, the second story be much smaller, to really try to fit in. And our neighbors are extremely supportive, as you see there, of our drawings and our plans. That's just all I have to add.
Mr. Noxon, let me ask you about these items. I'm just trying to figure out how the question would be. If they weren't here, would the staff have been more inclined, given the narrow width of the house without those planters, to have recommended approval of the, or is there some other factor? To me, that was one of the major factors as I looked at the report before I heard all of the information that was leaning towards supporting the staff's recommendation. So I'd be interested to hear the staff's reasoning for their denial beyond what we've read.
I think our main issue is that this is a conforming lot. It's more than a conforming lot. It's 62 feet, whereas 60 is required. In cases where we've supported use permits on corner lots, they've been on 50-foot lots or even less. In that case, there's a 17-foot wide house. There's not much you can do with that. That takes some serious design skills to get something livable out of that. They can get a 29-foot house and still have an eave overhang go 4 feet into the setback for that little stoop on the front, as well as, bay window without floor space, some of these window wells, other items. So we see there are by right options that could be done easily on this lot.
And yet the neighborhood is supporting lots frontages of the size that they're proposing. And they didn't go as tall as they could have by another by right option.
That's correct.
So there's a balance there. And they're not huge.
And that was my point, Madam Chair, my position, looking at an earlier case where I said it seems like this is large. This is not the case here. The rooms are not excessive. They're not more than generous, I think Ms. Freshman put it.
And
it is new. it is new construction, and that's what that's the note that I'd written on it when I went through the reports earlier today, but,
And it's always the balance for me when I look at these in terms of the conformity of the neighborhood and how the neighborhoods fit in, how the proposed design fits in with that as compared to what the by right option might be, which could be more detrimental to the neighborhood. That is, if you went on this lot with the height that would be allowed, I think that would be more of an encroachment. Plus by resetting the building location and into conformance with 3 of the 4 setbacks, it's a lot less of a problem than I think it would be someplace else. And if it were an interior lot, I'm not sure they'd have the same setback either, would they?
not at all.
So, if again, this is where the corner lot to me plays in a little bit, and they have worked very hard to get 3 of the 4 setbacks met, which always is a very positive attribute in my looking at options. And yes, I do understand that there are other options, and it's one of the things I weigh a lot. But when the proposal comes in modest, as opposed to there are other options and we've built to every inch of the space, this is not that kind of a case. Mr. Russell.
Well, I looked at, I think you stated that very well, and a lot of these numbers look small because they're to either these planter boxes that may go away or be lower to window wells that, well, the window well on the left side is one that is derived from making the bedroom down there a sleeping room by building code. But, to me, the telling number is that it's 9 feet to the wall on that side, and that's the number for the full height of the building. And then, as it was pointed out, to build something as a matter of right with less taste could be taller, boxier, less designed, as we sometimes see in by right development throughout the county. So the numbers to me are 18 instead of 25, and 22 to a porch instead of whatever that would be, and 9 feet on the left side.
And that might be less if those planters go away.
Well, it won't be less. 9 feet is to the wall. The planters go away, it would be 5. It's 5. You see all these really small numbers to these structures that are close to the ground is my point. And I'm looking more at what have we got running the full height, and what could you do if you said, okay, well, forget it, and we'll just build a box 3 stories tall with a flat roof, 35 feet, to get the space we need.
So that sounds like ready for a motion.
Madam Chairman, I move that the Board of Zoning Appeals adopt the alternative resolution in our packet that would approve use permit with setbacks as requested by the applicants, subject to the conditions of that alternative resolution.
Second.
Been moved by Mr. Russell, seconded by Mr. Smith. All in favor?
Aye.
Opposed? No. So motion carries 3-1.
Thank you very much. Really appreciate it.
Okay,
Actually, Mr. Knoxon, before we do this, can we take a 5-minute break? Just
don't have to ask me.
we have 2 long cases coming up, and I want to make sure that we're not antsy. Or I'm not.
Long night.
A little longer than usual.
Thank you. That's because they know that they can't get on in January, so. The white homes, the duplexes actually showed up. Over there on the right side behind the glass. First time she ever showed up. The way directly behind the glass. What? I'm bringing her in. How are you doing?
Good to see you.
You too. Hope I didn't put you through too much of the ringer. A lot of changes you all made, so a lot of back and forth. Next month we have, I think, 22 or 23 as well. So it's a lot. Business is booming, man.
Appreciate you.
Certainly. Came on 2011 or 2010, I think. They do. Not that I know of. I know where I worked before they were too. It was when I was an intern. I was in Dublin, Ohio, when I was in grad school. All their boards and commissions were paid, but yeah, it was just like you said, it was something very small. I mean, you're only given a few hours of your time a month, so. Guess you have to give him something for his time, right? I wonder how much the mayor of Falls Church actually has to do, though. Yeah, 109 or 10906, 14 VA. So do the 2 on 1023 first. You're saying now that Carol's there, he doesn't have to do? Probably right.
Okay. There we go. Oh, there are actually two back there, so.
Who's going to do 102.3 first?
What?
The coming order is the address.
Oh.
And they've requested to do 23 first. That matters.
Why?
I don't know. He can explain it. That's what she needs to pull up the other.
Hey, Cheryl, I think we're going to start with 23, which is 06. I didn't realize that. 06
1023.
or 906?
Yeah.
906 variance.
Madam Chair, is that going to be on the variance first or on the use permit?
We always start with the variance because you can't do a use permit unless you get the variance.
Wanted to confirm, thank you.
Yeah. Huh. But we don't have the builder here.
All ready to go? Okay. I'm going to
Yeah.
switch this up a little bit. We're going to take V-10906-14-VA-1 first, and that's on 1023 South Queen Street. This request is a variance by Arlington Designer Homes Incorporated to permit a total lot coverage of 56.3% instead of 45% as permitted. This is for the construction of a new 2.5-story detached single-family home with a covered front porch and a covered rear stoop. It's in the R5 zoning district on the premises known as 1023 South Queen Street.
And the recommendation is to adopt the attached resolution approving the subject variance with conditions. And Mr. Knoxon, can you explain why we're doing these in the different order? And
This was just at the request of the applicant. This one is probably the more contentious of the two because it involves a variance as well as a use permit, and it's on the smaller of the two lots as well. And we also have some opposition from a neighboring property owner.
I think I have I have opposition tonight on 905 and 906.
Probably for both. Correct.
I think so. We've got one for use permit, one for variance. Okay, I got it. That's why we have two speaker slips on everything, because we've got one for each. That's fine. All right. Let's start with questions for Mr. Knoxon. And if the board has none, I have one, which was raised in the letter we received today. What's changed in the application from when the staff had previously recommended denial to today, where you're now recommending approval?
There's been some changes to the house, the size of the footprint, the placement of it. Really, we've had more of a chance to go through it and look at the actual hardship issue on this lot. Before, I think we took more of an issue of it because we had an opinion that maybe having one house straddling the 2 or 3 lots together would have been a better option. But staff did write a determination a few years ago stating that these are 2 buildable lots, even though they are very minuscule. There are 2 buildable lots, and they do have a hardship because of that.
Mm-hmm. So that's been reconsidered since the last time you looked at the issue?
Correct. More thoroughly considered, I would say.
Well, yes. I assume, I mean, the previous reports did indicate you had looked at those issues, but I think it's just helpful to get on the record what has changed since there was a change of position. And the designs didn't look that much different to me, but I know you look at these much closer than I do.
And we also had some ordinance changes as well. One of them was, you'll see it further down the analysis, where we had suggested to the applicant to put in the strip driveway, which would have saved them a lot of coverage and possibly kept them from having to get a variance in the first place. But the ordinance has changed to count that strip now. So they need the full, 36 by 8.5 foot wide driveway, which is a lot of extra pavement.
Okay, any further questions of staff? If not, Bill, how do you want to do this? You want to come first? Do you have an agent representative? I'm not sure.
Let me just start out, if I might.
Record, it's William B. Moore, 4719 24th Road North, Arlington, Virginia, and you're the owner of Arlington Designer Homes. Is that correct?
Right. Madam Chairman, members of the board, I'm Bill Moore, and with my son Andy, we're the principals in Arlington Designer Homes. We've been involved in building since 1986 in Arlington County. We've built over 90 homes, and Andy and I both live in Arlington, and Andy is graduated from high school in Arlington. We were approached by Mrs. Butler's attorney for help in developing these lots. They're 3 small lots. They asked our help and what we thought the potential might be. When we looked at it, there were different options. You could put all 3 lots together and build one house. We thought that Arlington already had enough big houses, and one big house would be out of the level of prices in this particular neighborhood. The neighborhood, Arlington View, is a really nice neighborhood. It's a nice mix. It's close in. It's near Washington Boulevard and Columbia Pike, and it's diverse and houses are well maintained. The lot that's involved here, again, is a small lot, but zoning has determined that this lot and the other one were, in fact, buildable. And what happens is the state statute states that with the implementation of a zoning ordinance, the prior use is a vested use if it existed prior to that ordinance, which is the situation here. This is a transferable use. In other words, it doesn't end when the owner dies or when it sells it, it's transferred on to the next owner. We are contract purchasers, is contingent upon the zoning and approval of the setbacks. The staff, when working with them, wanted a smaller house, which we did. We started off 25 by 31. We reduced it to 25 by 25, which I think is as small as you can have an economic unit for a house. We work with the staff to try to minimize the coverage. As they point out, on the strips, we converted the strips. There's a piece of this lot which was without any taking by the county. Queen Street was paved over, 164 square feet of that lot. She was never paid for that. And under the calculations that the staff uses, that's counted as coverage. The use of the lot, I think, is its highest and best use. There are several different properties that have been granted FAR exceptions. And these exceptions are identified in my statement of support. They're in North Arlington. There are 3 of them that were granted, one for a swimming pool terrace, one for a large addition, one for a conservatory. I would like to suggest that for an FAR increase to allow affordable housing in South Arlington has merit and should be considered in accordance with what use is being made of that property. There are small houses built throughout the Arlington View area. The houses at 1014 South Quinn is a 512 square feet house. The one we're proposing is 625 square feet. 1027 South Quinn Street had a base area of 552, and 1025 South Quinn Street had a base area of 713 square feet. But we worked with staff, they recommended approval, and I would ask that you approve this application.
Thank you. For the record, I want to note that I am actually a purchaser of one of the Arlington designer homes 14 years ago, so I'm well aware of that, but I want to make sure I put that on the record just so everybody's aware of that fact. I don't see that it would be a conflict of interest in deciding this issue, but again, want the record to be clear. Let's see. The next speaker I have on the use permit, again, Ms. Williams, these are 3 minutes. Well, no, 2 minutes now beyond the applicant. So it would be Richard Knight, I believe.
Madam Chairman and members, my name is Richard Knight. I'm here on behalf of Mrs. Butler, who is the owner and the contract seller. She would have liked to have been here tonight, but she is of advanced age and infirm health. She's 84 years old, but she wanted me to come and to talk to you, tell you some more about her. She is a longtime Arlington resident. She lives right across the street from this subject property. She was born in the place that she lives now, although the house she lives in now is a new house, but that's the area that she grew up in. She is of an age where she is counting on this property for her long-term retirement and to be able to live into her senior years with dignity. This is a very substantial part of her estate. She inherited part of this property. It came from her great-grandfather. She was given another small section of it by one of her relatives, and almost all of the property was owned by her relatives, and she purchased it over time. She has put a lot of effort into pulling this together because she started out with an inheritance from her grandfather. And
that explains the pricing that we saw in the report with regard to the cost.
Yes.
She got some of the property at below what might be market value.
And she'd inherited some, yes, and some was a gift from her nephew. So it was kind of a family endeavor there to assist her in her old age. She also wanted you to know that directly across the street, I think it's at 1026, years and years ago, there was a residence there. That was her great-uncle, being her grandfather's brother. So this whole lot, from one end to the other, was either inherited by her or given to her or purchased by her. She just wanted you to know all that. Thank you.
Thank you. The next speaker, I believe now we go to speakers in opposition. And I think I'm going to start with the representative we received the letter from. So, Ardolis Ronis? I see it's Israeli.
It's Aristotle Cronus. Good evening.
Aristotle.
Yes. Good evening, members of the board. Thank you for having me in front of you again. Again, attorney for Joseph Holtman and Laura Roth, owners of 1103 South Queen, directly next door to the subject property. The reason you got that letter late was because they got notice of this after the staff report was done, hoping that you all did get a chance to read that letter. To the Ms. Chairwoman's point regarding nothing's changed about this application, absolutely. Nothing's changed about this application. In fact, it is now actually closer to my client's property, where the 5-foot setback is now on our side. That is causing going to be a detriment, sight lines, privacy, all these other things. The lot coverage is now worse. That ordinance change, they could have gotten this approved before the ordinance change. Ordinance change affects everyone equally, so there's no detriment to there. The only reason it seems like they've changed is because of these 2012 determinations. If you read these determinations, they are very specific. It says you are going to need a use permit, you are going to need a variance. It's not a carte blanche to go ahead and build whatever they want just because they've been deemed buildable. There is no hardship now because they have been assembled into 3 lots. You can't say that this was purchased in good faith because these were all purchased in small little portions with the thought of assembling into one thing. Now it's an afterthought to come back 10 years later and say, can we split these into small little lots? The purchase prices are low, and in fact, if any sale that they do right now is going to be a windfall to them. because of these low purchase prices, it's not giving them any kind of a detriment for the fact that they can sell and market one house on these lots. And for that fact that it's all vacant, they can assemble it, there is no hardship, this would be a special privilege to allow them to build two houses where there really, at this point, should only be one. These lot sizes are small, but the rest of the neighborhood is also small. Everything on 11th Street, 12th Street, 13th Street, 4,000 square feet or below. This could call for a general rezoning of properties in that area, but we can't have every single person who's got a lot that small coming in now for redevelopment variance every single time. Even the things that were listed were, as examples, were all by variance or use permit. So there's nothing, the hardship is there. I'm gonna let my client speak to that coming up, but we would ask for it not to be approved. Thank you.
Actually, I think we have another speaker in favor, but he was with all the other slips, and I'm past you, Mr. Barnes.
Thank you, Madam Chairman. I'll just speak on this matter. I just want to tell you it was a Herculean effort to get here, and it took a lot of hard work. Mr. Knight had to go to court and quiet title. What I wanted to share with you, and the reason I was asked to speak tonight, this was actually 3 lots. And I think it's important to point that out. When we sought when we submitted our buildability request, it came back that 2 were buildable and the 3rd was not. We had an opportunity to appeal that decision. I think we would have won, but who knows. But instead, we decided to let that right lapse because we thought it would just be, pushing it too much with this neighborhood. We did feel, though, that 2 lots would be appropriate, and we worked with the zoning office with an understanding when we didn't pursue that 3rd lot that they would support reasonable requests for building on these 2 lots. These were really old lots. It was done, I think, I don't want to say something inaccurate. I think it was the 1800s, because I personally went back and looked at the title, and there was clearly separate lots, which, as Mr. Moore said, are vested under today's rules. So there are 2 buildable lots, and for which Ms. Butler has a right to expect a reasonable use. Thank you very much.
Thank you, Mr. Larson. Okay, and now I believe we have...
Can I have a minute of rebuttal?
No, not now, not yet, Mr. Moore. We still have other speakers. So I believe I have Mr. Holtman. So next speaker against.
Thank you very much for the opportunity. I appreciate it. I just wanted to explain a couple bullet points, which hopefully would give you my perspective on a very layman's practical term. As Mr. Moore said, Arlington Views is a very lovely little neighborhood, and if it's appropriate, may I pass out a couple pictures?
Sure. And just while you're doing that, for the record, you're at 1103 South Queen Street, and that's located where in relationship to the subject properties? Next door or across the street?
Directly next door.
Is so the red brick, well, they're both red brick, I guess it doesn't help. With the dark roof or the gray roof?
Which roof color is yours?
Dark or light?
Well, there's 1 and 2 for each.
No, I meant
Oh, I'm sorry. Gray, light gray.
light gray. Okay, thank you.
So, if you would, picture number 2 is the house, in regards to keeping Arlington View a very nice little neighborhood. Picture number 2 is the view from across the street from my house. So my point here is kind of, this is a house that's going up right now, obviously. This is what happens when, these big construction projects get put up next to smaller houses. So I'm very concerned.
We were sorting the pictures, and where is this picture 2 you're referring to?
Picture number 2 is the view directly across from my house.
Okay.
So my point is just, this is what happens in a nice little neighborhood when we put up these huge structures. And I would hate to have that happen next to me also.
So is it, just for clarification, so is this the one that's on the corner here in the picture? Where the, like, right now, there's a little,
Yeah, someone's mouse is there? Yes,
Yeah,
that's
where that mouse
exactly,
was.
that's exactly right.
that's where this picture
That's
is.
that construction,
Okay.
yes, yeah. Right now, the neighborhood is undergoing a major reconstruction with the Washington Boulevard and Columbia Pike Interchange Improvement Project, which hopefully you guys are aware of. It's created a ton of disruption in the neighborhood, and it's going to even further because Queen Street will become the major route where the stoplight's going to be onto Columbia Pike. So my concern there is increased traffic flow. Right now, as it stands, there are townhouses across the street from me to the left, and the people that live in the townhouses already crowd the streets. These two cars here are a good illustration. Perhaps they're members of the townhouses. So this is part of our parking problem that we have right now. So if we put two more houses here, it's just going to exacerbate that problem. And then finally, picture number one that I printed out is the view from my driveway, my garage. Looking to the left is where the proposed lots would be. And, you know, obviously I didn't have time to figure out exactly where the point of the house would be, but it's going to be approximately 8 feet past my fence. It's going to block my entire view from getting out of my driveway. And I think that that's part of the variance request, is that it can't affect safety concerns. And I have that very serious safety concern.
Okay.
If I may, one other point. There were, I think, 9 signatures asking for the variance. When I mapped those requests out, the closest person was 2 blocks away. Most of the people who signed that request in favor of the variance were 3 or 4 blocks away. Again, the closest one was 2 blocks away. I appreciate your time.
Thank you. Another speaker is Patricia Healy at 1027 South Quinn Street, Arlington, Virginia. We may be looking at your house now, is that correct?
Actually, not the tan house, but the little yellow farmhouse. Good evening, my name is Patricia Healy, and I live at 1027 South Quinn Street. And my house, I've actually lived there since 2000 when we bought it, and our house is 110 years old, so ours is before anybody's. And I know in the 1920s is when I saw some of the plats being divided. I did have a concern. I had a letter dated April 8th and one dated May 7th that my husband brought in and submitted to Drew. And I didn't see those letters included in this pack. I know I had called after the May 7th and mentioned that they weren't included, and you'd said you'd check into it and include it. So I didn't see our letters, and they were assigned by, see the tan house there, the owners of the tan house, as well as some of the other neighbors that are adjacent or catty corner, like the Wrights, which are in the yellow brick house there behind the trees. So I wasn't sure where our letters are, and I have another copy of another letter we signed tonight saying, okay, this is reiterate. You know, I put it in green so it wouldn't get lost. So we reiterate our concerns. I know my husband and I, he was here earlier, he had to take our daughter home. We're fine with one house, but we feel like the 2 houses is excessive and very intensive. If you combine the 2 lots together, they're 4,525 square feet, so 4,525 square feet combined, and to have those 2 houses is very excessive. And there's no requirement for stormwater or grading plans, and we're just worried about all that water coming into our backyards, as well as just, I have a lovely garden, and it would just seem like, you know, over a 30-foot wall behind us. So, sorry.
Thank you very much for coming.
Thank you.
Over the course of the conversations, you may have more opportunities to speak as well. So,
okay.
If you didn't get everything in now, you'll have another opportunity.
Thank you.
Or
Can
2.
I give the letter to
Why don't you give the letter over here to Mr. Russell, and we can each take a chance to look at it. thank you. I think, just want to make sure, there's no other speakers, is that correct? Those are the speaker slips I have, so I think we're ready to open this for discussion.
Madam Chair, I would like to ask Mr. Cronus, you concede the point that there was a determination made that those are two buildable lots.
I see that determination, but if you read that determination, it very much, because I know Ms. Cozart is very careful about the words that she uses in giving any of these determinations, and she specifically says in there that these are going to be subject to use permits,
I saw that.
use permits, variances, all of these other things, and did
Which
not
is
absolutely say, thumbs up, we're going to carte blanche support you on any of these things. Still has to go through the normal process of reasonableness and all of these other things. And specifically with the variance, you need to look at the variance with the actual criteria in mind. First, is it eligible for a variance? And then second of all, can we even grant one? And here, my argument would be it's not even eligible for a variance because these lots, this person didn't buy these lots and said, okay, I bought this, I know this is a buildable lot. No, they had to go 10 years later after they consolidated the three and then split them and then say, okay, now can we split them up?
You've gone beyond the answer. I appreciate I appreciate the argument again, but you've gone beyond. So you say, yes, but she qualified that determination with, that doesn't mean, essentially you're saying, that doesn't mean that something can be built there. They're buildable, but what can be built?
I would also go to Mr. Lawson's point of earlier in the evening where he said that there was no reliance on those actual determinations and they could be reversed.
Well, then the South Carolina case that's cited, it would be a taking if they weren't allowed to build something there.
Something, but now they can build on all three lots.
No, they
and
can't.
I mean, I'm
Mr.
sorry?
Cronus, they could not build on all three lots because the county's already determined there are only two buildable lots.
Two buildable lots, but then they also said in that same determination that that third outlot, the 1,500 square foot, could be used to put the garage or any other thing as in terms of being encumbered by the lot next to it, or all three lots if you decided to make all three lots. You could actually combine all three lots pursuant to what the determination was made. Because that third lot as an outlot could be, you could put an accessory building like a garage or something of that nature on there. Those determinations were specifically mentioned in the determinations that were made.
Which we have before us. Thank you very much.
Thank you.
Mr. Moore, I think as the applicant, I will allow you at this point, if you have anything further you have to say, or
The only thing I
just
wanted
wait until you get to the podium. You have to come to the podium, Mr. Moore?
Excuse me. The only thing I want to point out was our exhibits 11, 12, and 13, which deals directly with the issue that was raised by the adjacent property owner. It shows that there is approximately 16 feet side yard to the garage, plus a 20-foot garage is 36 feet, plus 5-foot setback, that's 41 feet separation, as well as the map in the back of the packet which shows the separation from the houses behind. So you have separation, it shows one of the speakers talked about being in back of it, but you've got a separation to the lot line of 61 feet and 48.5 feet on the two houses directly behind the lot. And I would submit that probably that's more separation than most of the members of the board here have from a house next to them. But anyway, I just wanted to point that out. Thank you.
Thank you, Mr. Moore. So we're open for deliberation.
Madam Chair, this family that just submitted the letter, it said that there was another letter that was submitted that you don't have that? Okay, all right.
Okay, I think that answers the question, and you're talking from your chair, so I'm sorry. No, that's okay. So for the record, the letters that you had previously submitted are not in the record. Thank you. Again, ma'am, I need you to stop speaking. I mean, you're not being recorded, and B, you're not being asked any questions right now, so.
Madam Chairman, I know staff has recommended approval, but I'd like to ask staff if they could accomplish the same area, I mean, the interior space in this structure by making it have a smaller footprint but be taller. I'm not saying that's exactly right, but they could make it taller and narrow and have a smaller footprint. Isn't that true?
Small footprint already.
It is a small footprint already.
It is pretty small as it is. I suppose they could.
Not saying that would be tasteful.
Yeah, exactly.
In terms of trying to have a smaller, to seek smaller relief from the ordinance. They're at 56.3 square feet. It could be a smaller footprint, but it wouldn't necessarily be practical. But it could be done, and that would be a horrendous structure.
Mr. Noxon is nodding in the affirmative at the comment.
Yeah.
I guess the other question would be, in terms of considering a by right option, given the zoning administrator's determination, did the staff consider what a by right option might look like on these buildable lots? No, in the past.
I think it's explained in the use permit, the buildable area. It's something like 7 feet deep at most by 18 feet wide, 13 feet wide, something like that. I know I have something in the use permit that states that. As we're going with the variance coverage, your permitted coverage, total lot coverage, that's the house, the driveway, front porch, whatever else you have, is only about 988 square feet.
Mm-hmm.
So doesn't give you much.
And the environmental, Madam Chair, if I might ask staff, the environmental issues that one of the neighbors posed, those are handled by Department of Environmental Services in reviewing the site plan, is that correct?
That's correct.
And any amelioration required would be required by them, is that correct?
That's correct.
So the question before us is looking at the standards that have been both spoken by the attorneys representing the opponents and in my comments this evening when we do opening, as we always look at with variances, is whether the strict application of the ordinance would produce undue hardship, that the hardship is not generally shared by other properties in the same zoning district, and that the authorization of the variance will not be of substantial detriment to adjacent property, and that the character of the district will not be changed by the granting of the variance. And normally these are really very difficult questions for me because usually there are other options on these lots, or there's a real question at the end of the day as to why the zoning administrator made a determination that they were buildable. Usually not this zoning administrator, usually a previous one. Sometimes because I look at them and go, they're too small, they're not going to have any buildable space. Here it seems very reasonable that the determinations that they're buildable existed. I have no qualms with that. I think there was a recognition that there's not room for 3 buildable lots. But that I find no fault with the determination that there's 2 buildable lots. Given that, those 2 buildable lots are a hardship that is not shared by the other properties in the neighborhood, making the variance analysis much easier in this case than it would be in other cases. And in regard to the substantial detriment to the adjacent property, in light of the conversation that Mr. Smith just had, I think the failure to grant the variance and attempting to force them to do something outside the context of that would, as Mr. Smith said, be horrendous. So this is, as I said, an interesting case in that the difficulty in finding the variance standards is less than it normally is, at least for me.
Madam Chairman, it was also interesting earlier, Mr. Lawson commented, he's not in a room right now, that he's usually on the other side. Mr. Cronus also, who has been before us many times, is also often on the other side seeking dispensation from a strict application of the rules. These are highly skilled lawyers in this area who make excellent arguments all the time.
Ms. Freshman.
But I associate myself with your remarks, though, by the way.
And as do I. I think that it's not an easy case, but I definitely concur that they're buildable lots. It's perfectly obvious, as was pointed out by one of the speakers, that in order to make it buildable, you have to get variances and other kinds of exceptions. So, of course, there are no guarantees, but it's still it's difficult. And I think actually that two small houses, and these are very small houses, are probably more marketable and less offensive than something that could be done by right.
And I would say even and less than what have been being proposed by the opponents, making, which the applicant is not required to do, but if one house were put on this property, I think it could have a much more detrimental effect on the neighborhood. I don't think they realize how big that could be because they see this as still a small property. But if you were to combine all of that lot space and try to build it into one lot, then that house could be much larger and have a much more detrimental impact than two small houses would have on the neighborhood. And I love the diversity of the neighborhood now and would hate to see a precedent for a very large house. Mr. Russell.
I concur with the rest of the board members that the code requires providing some use of the property, and that what's been arrived at is probably the most compatible minimum that could be worked out. Thank you.
In light of the deliberations, are we prepared for a motion?
I move the Board of Zoning Appeals adopt the attached resolution approving the variance V-10906-14-VA-1, subject to the conditions.
Second.
Moved by Ms. Freshman, seconded by Mr. Smith. All in favor?
Aye.
Aye. Carries unanimously.
Make sure I get the right one here.
Associated use
use permit. Now that we've gone out of order. Okay. The use permit is case number V-10906-14-UP-1. This is a use permit request by Arlington Designer Homes Incorporated to permit a setback of 6.4 feet to the air conditioning unit instead of 8 feet as required, 6.9 feet to the stoop, and 8.9 feet to the eave and 10 feet to the wall of the new home from the rear property line instead of 25 feet as required, then 4 feet to the eave and 5 feet to the wall of the new home from the left side property line instead of 10 feet as required. Also 11.1 feet to the areaway, 15.4 feet to the planter boxes, 15.7 feet to the porch, 19.3 feet to the eave, and 20.4 feet to the wall of the home from the South Queen Street right-of-way instead of 25 feet as required. Finally, an aggregate side yard of 12.5 feet instead of 18 feet is required. It's for a new 2.5-story detached single-family home with a front covered stoop with stairs, a covered rear stoop, and a rear air conditioning unit. It's in the R5 zoning district on the premises known as 1023 South Queen Street.
And the recommendation is to, I'm sure, let me get to it. Sorry. Have it out of order. Adopt the attached resolution approving the subject use permit with conditions. We have the same lineup of speakers. I would ask if anyone wants to add anything to the record with regard to the use permit beyond what was spoken about with the variance. I know there are some separate issues. In light of that, why don't we start with the applicant, Mr. Moore?
I would only direct the board's attention to page 3, where I think there's listed all of the other variances that have been granted in this area, or changing the setbacks. And I submit that the setbacks that we are discussing in this application are similar to that and are not unreasonable in light of the situation. There's also 4 additional, let me just leave it at that, and I rely on the findings and the recommendation of the staff.
Any questions of Mr. Moore before he sits down with regard to the specifications of the home, which is a different issue than we were just discussing with the variances? So are there any questions? I guess, Mr. Moore, at this point, it would be the time to talk about what were the options that you considered in terms of making a smaller footprint on the house, up with the house, and what were the pros and cons of that?
We looked at, one, the staff had suggested that they would, as far as a minimum house, it's a minimum size, 25 by 25. It's in keeping with the smallest footprints of any house that you have in that area that's still viable. We did go ahead and increase we put a basement in it and a half story to try to increase the area inside, but there's just a limit as to what you can build. And the economics of building a house, the larger you get, actually, within reason, it's more cost effective. You've got the same cost for engineering, you got the same cost for meeting all the environmental aspects of that, whether it's a small house or a big house. So we looked at, I talked to the lady at the affordable housing head of that and discussed with her what would be a house that might work for somebody that's a starter home or in affordable housing. So we took that consideration. We looked at the various houses that were being sold. All of them were above that, other than, if you got a townhouse, but as far as a single-family detached house, our investigation didn't reveal anything smaller than 25 by 25.
And what about looking at height? If you could put on the record your evaluation about building something, as we've been talking about
2.5 stories is what it is.
That's below the 35.
Yeah, it meets the 35-foot calculation.
So you are to that limit.
Yeah, we're within that.
Are you at that or below that?
Below that.
Yeah. So you didn't build something that's at the max, is what I'm saying.
Yeah, we did. Not the max. We left it before on the height.
Right.
Okay.
Thank you.
Thank you.
Okay. Our next speaker would be Mr. Knight. Is there anything additional you would want to share?
I don't really have anything else to add.
Okay. Thank you. The next speaker then would be Mr. Cronus.
Good evening again. Aristotle Cronus, attorney for the owners of 1103. Now that we're, beyond the variance issue, we have to actually look at what are they actually building here. And as I mentioned in the variance, these plans have changed 3 times now. Originally, the reduced setbacks were on the farther lots. Now, in May, they've put the 12.5 aggregate onto this lot, which is actually closest to what's actual real already built construction. Now, in the last iteration, they've flip-flopped, which is going to be the short end. The 5-foot side is now closest to my client's property. So, all those things about visibility that they said, it's not going to be a detriment, was it on, which design was that based on? Because now that house is now actually 5 feet closer. You actually have to go back and look at what the criteria for a use permit is. A use permit was established as an alternative to a variance for essentially by right construction to do things like save trees. We heard about that earlier tonight. Preserve natural landform. Here we have a vacant lot with none such of these issues. There's no reason why we need to be giving sort of a special privilege, particularly without studying what else can be done to reduce basically the impacts on the 1103 neighbors at this point. You know, I mean, we basically have a blank slate because that is a very flat piece of open land that you can do a lot with, and we kind of feel that, you know, at this point what they're really trying to do is put 2 houses in, and you know, affordability aside, I'm thinking it's really that 2 houses are going to sell for more than just 1 house is, frankly, to these folks. So that's really the argument with respect to the use permit, but I think it needs to be studied more. Maybe deferral is in order to actually see what it can actually be done to reduce the impacts on 1103. Thank you.
Thank you.
One question, though, Mr. Cronus. I'm trying to find in the staff report, I thought I saw a mention of the, I think you alluded to it, an engineering report with respect to view, and maybe staff can answer that. Which?
There was a delashment letter. I'm not sure what page it's on, or if it's, I believe it's in this use permit, but it was very vague in terms of, I don't even know if it was.
Maybe it was in the variance. I know I saw something about.
But as my clients testified earlier, there is particularly now that you're putting the house on their side as opposed to the driveway on their side, it makes, now you're adding essentially an additional curb cut.
It's in the, okay, thank you, Mr. Cronus.
Thank you.
Any questions of staff? If not, Mr. Holtman?
Thank you again. I'd like to talk for 30 seconds again about the safety issue, which is my primary concern. From the Arlington County website, and again, I'm just kind of a regular guy trying to figure it out, but from the county website, the first clause, it says, the BZA shall not approve a use permit until it finds, and the first asterisk is, it will not affect adversely the health or safety of persons residing in the neighborhood. So I would ask you to consider that. Thank you.
Thank you. Ms. Healy, at this point, if you want to come forward and add additional things, that would be great.
Thank you. Sorry about before. I know, just going back to the letters, I know that our neighbor Christopher Philbin had emailed one of the letters because I had been copied on it, and I can send copies to Drew tomorrow. I know it's going to be
Well, I mean, I
over
think
with,
at this point, what
yeah.
would be helpful is if you summarize the contents, since that would be put in the record.
Okay.
Rather than, because tomorrow the
Sure,
hearing
it's
will be
too late,
over.
right. Basically, our concerns were just the environmental impact, you know, the runoff, that we felt like these lots should be combined in just one house built. All the neighbors felt comfortable with that, but having the 2 houses, we just felt, you know, the light coming into our gardens, you know, because they are close to the property line.
Do you understand that we've already gotten past
Yes.
that point?
Yeah. Okay. I'm just saying what was in the letters.
Mm-hmm.
And then, what else? Oh, the traffic. We are concerned about the traffic on the street, and also the consideration of that, you know, there's possible building at the Carver Homes that will be happening, and all the traffic will be run on that street and back to in the back of the neighborhood. So those were our main concerns.
And have you had a chance to look at the actual designs that are being
Yes.
proposed? And do you have any comments on those?
On the designs, no. Thank you.
Appreciate that.
Yeah, I did have one comment about how the consideration that on the back, I know we've passed the point of the 61 feet. I know my husband and I have been considering doing something with our house, maybe possibly adding on in the back, and to think about that 61 feet now, on the back, that he was of using that as part of his setback, or just thinking of it that way, that our building will be that far away from his building.
He doesn't think about it that way, Ms. Healy,
Okay.
because we only look at the actual parcel, and
Right.
the zoning can only look at the parcel he owns.
Okay.
Now, as you heard listening through this evening, there are occasions when on a corner lot or a lot abutting a driveway or something that the county might make a recommendation to accept something, because that would be built into a barrier.
Mhm.
That wouldn't be applicable to the lots that we're talking about here, because we would just go with the boundary lines. So it would have no impact whatsoever. You would be, if you decide to build on your property, it would be within whatever the setback is for your property, and his setback has no impact on that for you.
Okay, thank you.
Okay?
Yeah, thank you.
I think that's all the speakers. Again, am I correct? In light of that, deliberation? I guess, Mr. Moore, would you just clarify, the one thing that we don't have on the record is whether you flipped the design and the proximity to Mr. Holtman's house, the one here?
Yes, the driveway needed to be 8.5 feet. There was concern by the adjacent neighbor on the sight line, and by moving the traffic, the driveway to the other side, it minimized any chance to be a conflict of cars exiting from his house and from this house. And that worked better with the basement. And you're talking about 3 feet. I mean, basically, he's got a 16-foot side yard, and you can have houses each with an 8-foot side yard with a 16-foot separation. So you're talking about 3 feet is what you're talking about. And in the distance he had, 41, it was a very small percentage.
Thank you, Mr. Moore. I think, again, relevant to the discussion we have, the reason, from what I'm hearing from your testimony, that you moved the driveway was to help with the sight line and therefore the safety of leaving the driveways for both of the homes. Is that correct? Was that what you just said? That moving the driveway makes it easier, or it helps with the safety of coming out of those?
Yeah, I mean, there's less chance of a conflict between the neighbor's driveway exiting and the one on this one if we put it on the other side.
Thank you, Mr. Moore. That's what I wanted clarified, especially because I think that also speaks to the concern of safety a little bit that's being driven with regard to coming in and out of that home. And anything additional? I guess the other thing I wanted to point out, though, to you, Mr. Moore, just as I did with Ms. Healy, the fact that he's got the 16 feet doesn't really help you necessarily, because, again, we'd be looking at just the setback you're asking for, and overall, that's being evaluated based on the property size that you have and the placement of the home that you're putting, not the fact that there's a larger barrier next door to it. At least that's, for me, the factor that's coming into play.
Madam Chair?
Yes.
I'm going to try a motion. And it is to adopt the attached resolution approving the use permit subject to the conditions which are listed in the staff report.
Been moved by Mr. Smith, seconded by Ms. Freshman. All in favor?
Aye.
Motion carries unanimously.
We're going to skip back to the first use permit on the adjacent lot.
Actually, it did make sense to do it in this order.
This is case number V-10905-14-UP-1. This is a use permit request by Arlington Designer Homes Incorporated to permit a setback of 6.1 feet to the air conditioning unit instead of 8 feet as required, 7.4 feet to the stoop, 9 feet to the eave, and 10 feet to the wall of the new home from the rear property line instead of 25 feet as required, and 11.6 feet to the eave and 12.7 feet to the wall of the home from the South Queen Street right-of-way instead of 25 feet as required. Also, 3.5 feet between the eaves and 5 feet between the walls of the main building and a detached garage instead of 8 feet as required. This is for the construction of a new 2-story detached single-family home with a front stairway, covered rear stoop, covered front stoop, rear air conditioning unit, and a detached 1-story garage. This is in the R5 zoning district on the premises known as 1021 South Queen Street.
And the recommendation is to adopt the attached resolution approving the subject use permit with conditions. Same lineup, Mr. Moore?
I have nothing to add to what the staff has said. We worked with the staff and made some changes that they asked for, and I think they've hit the nail on the head and recommended approval. Thank you.
Thank you, Mr. Moore. And Mr. Knight, nothing further? Mr. Cronus?
Again, Aristotle Cronus, attorney for the owners of 1103 South Queen. So obviously this was the least objectionable of the two proposals for my clients, but at the same time, I still wonder as to what specifically about this application has changed that now has staff going from denial to now asking for approval. The only thing that, and this seemed to be a very simple change from the April plan to the May plan, was the movement of an air conditioning unit, which seemed like a very simple thing, and I'm just wondering why even the most simplest request of relocating an air conditioning unit there's been no, now it seems the staff is not even asking for that. So that's really, I think, the extent of my comments tonight. Thank you.
Thank you. Mr. Holtman? Oh, no, he's not on this one. Just Ms. Healy. I got used to the list. Mr. Holtman was represented by Mr. Cronus on this one.
Hi, Patricia Healy, and I live directly behind this home, and my concern...
Ms. Healy, can I ask you to speak up just a little
Sure.
bit?
I live directly behind this lot, and my concern was just the placement of the air conditioner, too. If I know the variance is granted, and my children's swing set is right there, and just the noise from the air conditioning unit being so close to the property line. That's all.
Thank you. Mr. Knoxon, I did have one question. Earlier this evening, we talked about air conditioning units, and it was 5 foot, and this one is 8 foot?
That was for side property line, less of an allowance on the rear.
Okay, thank you.
Madam Chairman,
Mr. Russell.
I have a question maybe that staff could answer. First of all, what is the reason for the garage to be as close to the house? I'm confused, probably by property lines.
The issue is we have that second portion, what you see is the south portion of part of Lot 6, which we have deemed unbuildable. Therefore, we will not allow you to erect a separate building on that lot by itself as an unbuildable outlot. Therefore, what we do is we make you encumber the buildable lot with that one, and that way straddle the lot line. So you're on part of the buildable lot and encumbering that as an unbuildable portion.
But I still have the same question. Couldn't it be moved over further on to south portion of south part of Lot 6?
No, it's on the other lot by about 6 inches.
To reach that line, the buildable lot, They have to place it there.
You're probably seeing the driveway line as part of the lot line. If you look between, actually right almost on the edge of the garage, you'll see that line. It says 61.83 feet. Some meets and bounds as well right there.
Right.
That's the actual lot line divider between the unbuildable portion and the buildable portion.
So what you're saying is that the garage has got to straddle that line.
Correct.
So it's got to be that close.
That's correct.
And it has to be a structure. It can't be the driveway.
That's right.
I mean, not provide, like the other one, providing spaces with, 2 spaces without a garage.
That's right. Well, I mean, they could push it up closer to the street and have one parking space on the parking strip and then one space in the garage and do it that way. But then they might run into setback issues from the street. But they would still have to have it, encumbering those 2 lots and closer to the house.
And encumbering, but driveway cannot be used to encumber a driveway only.
Not by itself. A building. We even stated in the earlier determination that you can use that separate lot for the purpose of having a driveway.
Okay, thank you.
I think it is right. There's one there too. I thought it was Quinn, no, not Quincy. I'm sure it was Quinn. Huh. Yeah. Oh. Right. That'd be an error. No further deliberation. Are we ready for a motion?
I move the Board of Zoning Appeals adopt the attached resolution granting use permit V-10905-14-UP1, subject to the conditions.
Second?
Moved and seconded. All in favor?
Aye.
Aye. Unanimously approved. Thank you very much.
Thank you. Good to see you.
Oh, yeah, I know. Especially because Mr. Knox.
Oh, we're missing one.
Is there a limit on how many times people can come? Does they mouse?
We're trying to add a 1-year limit.
I mean, do we have them all listed? Oh, this is only the 4th? Oh, but they've done it on 6 houses, so it just feels like it's a lot more. No, they've done more than just 3.
Oh, yeah, same thing.
That's what I'm saying, so, and then on that street, almost every other one. So that's what the neighbor said the last time? No, they're different. Although the speakers wrote them all together. Huh? What? Yeah, let's go ahead. These will take a while.
Okay, our last 3 cases are all associated. They've been here a few times before, as you all know. This is case number V-10888-14-UP-4. This is a use permit request by Len Capusta to permit a setback of 6 feet to the chimney, 6.2 feet to the eave, and 7.4 feet to the wall of the existing building, and 8.9 feet to the new 2-story addition from the left side property line instead of 12 feet as required. Also 10.5 feet to the eave and 11.5 feet to the wall of the existing building from the 21st Road North right-of-way instead of 25 feet as required for the construction of a new 2-story rear addition on an existing non-conforming 2-family dwelling. This is in the R5 zoning district on the premises known as 4133 21st Road North.
And the recommendation is to adopt the attached resolution denying the subject use permit. An alternative resolution has been provided should the BZA wish to approve the use permit. Questions of Mr. Noxon?
Madam Chair, if I might real quickly, if we said no, I'm sorry, let me if we said yes, but the county board said no, what would be the applicant's result?
They couldn't get a building permit to do it.
Okay. Because this is a 2-step kind of a process.
That's correct. Mm-hmm.
Sorry. It's because they're all testifying against it. Yeah. Okay, since there's no questions of staff, this additional questions, let's have Zaid Jahar. Who is the agent for the applicant. Is this Ms. Kuspa?
Yes. Good evening.
Oh my gosh.
Third time's the charm. Anyways,
Lynn
good to see you all.
Kaputsa.
How you doing? I'll let her take the podium first.
Okay, we'll let her go first, absolutely. It's
Hi.
nice to meet you. We've heard about your properties on many occasions.
Yeah, in fact, I wanted to mention about that. How it all got started was, I don't know if you're aware of it, my father somehow, I don't know how, but I actually saw the little ad saying 3 properties for sale all at once. So we've owned these properties for 40 years, and my father died in 1996, so he basically, had control of it up until that point, and then my mom, unfortunately, got a lot handed to her. And I was actually in California, and she asked me to come back because she was just absolutely overwhelmed. So I actually ended up taking over. I actually came back in 2006, so we basically just continued on, just renting it out as is. But anyways, in 2011, we were actually seeking to sell, and I had not remembered it since I was a kid and everything, and I just found these apartments were just amazing, and there was so much potential to them. And as you can tell, if you look at the other properties, they're run down, they need work. We've made them into masterpieces, just to look at them from the front street. So that's basically what we're trying to do. We've renovated, we've remodeled all 3 of the properties. And so I just wanted to, point that out, that's the history of it. And my mom presently we haven't been diagnosed it, but it's likely it's early Alzheimer's, and she's just not in a good condition to be able to continue. So that's why I took it over. Since that time, luckily I found Zaid to be able to help me with all of this. It's just amazing. I look at this and I just marvel at what it looks like, how beautiful it is. So basically what I've always hoped for is for each property to live up to its highest potential, inside and outside. And we are desperately seeking more space for the upper addition because, as you can tell with 4 and 4.5, wait, which one are we on, 3.3? They're all the same. But basically the second story, if you can look at that one, the second floor, actually 3.3 is a little bit different. But anyways, that smaller bedroom is really difficult to rent out because it is so small. It would be more like just getting a child, and a couple. And so that would basically make it just, a 1-bedroom with a smaller bedroom. So what we are hoping to do is to, being that the decks are already approved and structure is already there, and it's minimal demolition from what I understand, just removing the spindles and the railing, that we're hoping to enclose it just basically the way we enclose the sunroom in the front to give the extra space. Now it's an office for the upstairs. I don't think it could be a bedroom. It's like 6 foot something. But anyway, so that's all we're seeking to do is just add more storage closet, the office for A, and the bedroom would be the branch off for the second floor. We're not increasing any additional. We have 3 people on A because we have finished the basement, and the upper is just 2 people. So, we're not trying to add any more. We have adequate parking spaces now. I came in and there was only 3. We've now added 2 additional per building, and we're actually going to be increasing 2 additional, bringing it down to the basement. So we'll have 7 for that would be for guests and things like that, because North 21st Road is ridiculous to park on. I remember when I was a kid, you used to be able to park on both sides, but now the fire engine could not get by, so they moved everything over and put a sidewalk and all of that. Some homes have 3 cars, some homes have 2 cars, and it's just extremely difficult. But we have taken 8 cars off of the street just by all the parking spaces that we've done. So I feel that we've improved the neighborhood tremendously in that regard. I feel we've improved the neighborhood as far as the look. And, I understand about the construction. We have not done any construction since 2013, and yet 2138, right up the street on North Stafford, is in the middle of construction, has been for over a year now, and they went into foreclosure, and so it stopped and all that. And then right across from 4133, which is this, they just went in construction this past year also. See, there's construction, it's a given that this neighborhood is going to be built up and improved upon, and so all we're trying to do is just gain more space. The deck enclosures the decks are already there. All we want to do is just enclose them, just to be able to gain the extra storage space. Once we finished all the basements, it kind of used to be that B used to share with the basement with A, and now they have very, very little storage space, and that was a major problem. So, creating a closet in the bedroom really adds a lot of problems because it makes it even smaller. Thank you for hearing me.
Okay. Mr. Jar?
Yes. Nothing much to add on. I know it's already late. I just wanted to point out that I think the board, the staff recommendation was to deny because of the setback, on the left side of the property being 12 foot. When we got the deck approved, we actually have it indented into the building that way because I was told in R5 district the setbacks are 12 and 8. Now it's being changed to 12 and 12. I don't know if that was a staff mistake back then when they approved the deck, or so. Anyway, it was indented just to have it get approved by right, and now we're just enclosing what we have, and that's our last resort because we've been shut down twice on the upper additions. And I understand that was extensive to the neighborhood, blocking the sun, privacy issues. These are all in the back. Nothing in the back of these properties except for Lee Highway, which is about 50, 60 foot down the backyard. So I feel this is like a minor construction, and I'll just take your recommendation on it. Thank you.
Thank you. Any questions?
Madam Chair, if I might say, welcome, Ms. Kapusta. It's wonderful seeing you, and because it has been a lot of discussion about your properties, and hearing that bit of history was very helpful. And I want to say that Zaid has been very helpful to you, too. He's done a great job. Even though the outcome may not have been desirable, he's been a very hard worker, and he's been diligent and made good arguments, has been credible in each instance that he's been before us. That doesn't mean you're going to get a favorable result.
Okay, let's start the opposition. We have Adam Kovach, 2146 North Stafford Street.
Thank you, Madam Chair. Thank you, members of the committee, for staying up so late with us. I'm almost ready to say good morning to you, but I'll still say good night because we have 3 minutes left. You're aware of our concerns. I'll repeat them for you one more time. This is a neighborhood with modest small houses and modest sort of two-family duplexes. We would like it to remain that way, and for that reason, I would like these units to remain within the existing footprint, not to swell, bump out in any direction, in any way, up, down, or sideways. My main concerns are the same as always for pretty much crowding. Although we have assurances, or at least we've been told that this will not create additional rooms, I'm not convinced of that. I don't know what's going to happen in the long run. I do know more space means potential for more tenants. Something that's labeled as an office can someday easily become a bedroom. The second major concern I have is drainage, increasing the size of the roof and pushing out the footprint of the house just covers more of the ground. As you can see from the pictures, most of those lots are now paved over, if not with asphalt, then with paving stones, creating runoff problems. The curves have been shaved away for alleged parking spaces. Looks like parking spaces if you have a very small car, but it's a drainage problem for the rest of us. Aesthetics, one person's masterpiece is another person's North Arlington version of the tenement house. I don't want to argue aesthetics, but I can't imagine any sane person saying that this looks better than what was there before. It would only look better before if you don't like green space. And finally, never-ending construction, which I know you can't help us with because a lot of it is within any owner's prerogative. But believe us, there's a reason why so many of us come out every night. And as always, I tell you, there are those who can't come who agree with us. And I haven't talked to a single neighbor who doesn't agree with us. Thank you.
Thank you. And at this time, let me thank everyone for being here as late as we are this evening. Our next speaker is Stephanie Ann Lipinski Galano. Sorry, the Spanish in me have to.
It's the ex-husband's name, so we don't want to worry about that anyway. Good evening. It's happy to see you again. Apparently, every 5 to 6 months, we show up here and see each other and have some discussion. I would like to speak in support of the staff's motion for the denial of the appeal. I'm preaching to the choir, but just for the record, Article 16.2.5a basically says a non-conforming building or structure shall not be added to or enlarged in any manner unless it's made to conform to the regulations. This is an ongoing issue that we have. I have nothing personal towards Ms. Kapuska. But one of the problems that we have in the narrative, it says that the addition is a modest increase. However, the practical effect is absolutely the opposite. What we go to is, if you look at the plans, both for 4145, 4137, 4133, it has a master bedroom on the first floor, and then it adds an office and a sitting room. I think it's rather odd that this office and sitting room have two giant walk-in closets. I don't know about you, but that is a tiny bit questionable. Also based on the fact that this particular landlord had purchased a house up on the corner, 4144, and that was supposed to be a single-family dwelling. That now has 4 single guys in there with cars driving up and down and adding to that problem that we have on the space as far as parking is concerned. The landlord went and received a permit to fix the driveway, and what has happened is when we had the firehouse come in down the street, we were told that all the curbs and the gutters would be done. We'd get sidewalks according to the master plan. Before all of that, as far as leading to the runoff and the environmental issue, all of that was curb, and it all went down to the drainage ditches. I apologize, but at the end of the day, I do request that the staff's recommendation be supported. Thank you.
We have 2 more cases. You can say more in a minute.
Thank you. The neighborhood
No,
is...
no, I'm sorry. I'm saying, we have 3 cases tonight. You'll get to
Oh, I get to do part 2, the sequel.
Okay. Exactly. Yeah, 2 minutes on each case, guys. Terrence Wilson.
Good morning, ladies and gentlemen.
Good morning.
I think we heard some tonight about allowances being granted for situations with green initiatives, with preserving a tree, with an addition of a family member. I don't think that's the case here at all. I think the people who are speaking on Ms. Kapuska's behalf are those who get a profit from this. Those who will speak against it are the residents of the block, those of us who live on the block, raise families on the block. We've brought up in the past safety issues, security issues, ongoing construction, this year as well, noise issues, and we just ask that she not be granted allowances which go against Arlington's established codes and zoning laws. Thank you.
Thank you. And our final speaker that I have a slip for is Lita Miller. If there's another speaker and you want to put a slip in, you can do that. You've been here a long time. You might as well say your piece. I think they're aren't they on the podium right there?
I'll give you another one.
Yeah.
Where'd you put it?
Oh, did you give them? Let me see if I have, wait,
Phil.
is it Philip?
Yes.
Ah, I found it.
All right. They've all stole my joke about the good evening, good morning. My name is Lita Miller, and I live at 4127 North 21st Road, and that is directly, it's the wood kind of house to the, I guess, right of me. Thank you for hearing from myself and the other 21st Road neighbors. As mentioned, this is the 3rd time the neighbors are in attendance speaking out against any change to the size of the duplex units at 4133, 4137, or 4145 21st Road. After our last meeting here with you, I reached out to Ms. Kapuska to request she show and review further construction plans with the neighbors before submitting for permit or asking for variance. I was pleasantly surprised when Zed, Ms. Kapuska's contractor, reached out to me to discuss her next projects. Unfortunately, we met a few days before I received the notice about today's meeting. So obviously, she wasn't really interested in getting our input and feedback. As I told Ms. Kapuska, and as we bring here today, no additional living space at these properties are welcome. The newest attempt to increase density of these duplexes by turning the porches into interior living space is unacceptable. These were built as modest duplexes in the 1920s. Lynn's parents, and I did know her mother for a long time before Lynn moved back, kept these rental units in their modest design. The continued construction and desire to increase the size of the duplex is something similar to McMansions and I believe Lynn thinks she is doing the best for our neighborhood, but I disagree. Looking at the design in the application, the first floor drawing has an office. I understand, that's a bedroom. Lynn states she'll only rent to, each rental unit will only be to 3 people, but that's her word, and I'm not comfortable with that as a promise. Can I share drawing pictures with you guys? And these show a top picture of when Ms. Kapuska's mom was in charge of the property, and the bottom picture of once she was starting to be in the involvement.
We actually approved all of that, so we've seen those.
Well, yeah.
Thank you. Mr. McGeorge, Philip McGeorge, 4124 21st Road, North Arlington. I don't think you've been with us before.
I actually have. I was here for the first meeting about the addition on the roof.
Oh, okay.
I live directly across the street from one of the last properties down there. I missed the second time around. Unfortunately, I'm out of town. I'll probably be out of town eventually for the next, who knows how many of these we'll have. I'd like to see them stop. I don't know why we're asking for something that's non-conforming to become, in my definition, more non-conforming, mean encroach further on property lines for the purpose of just adding square footage for tenants and for somebody who doesn't live on the block. If there's a reason other than that, I'd love to hear it. Also, a lot of the stuff we heard tonight, I'm glad that the owner showed up this evening and gave her side of the story. I didn't agree with pretty much anything she said about no construction since last year. There was construction today, yesterday, Veterans Day, a holiday. As far as I know, it's all her properties. I don't know anybody else doing construction on the property. I know I did construction for about a 5-month period on a renovation. It's been done. It was scheduled. I talked to my neighbors about it. It had a beginning and an end, and I didn't ask for any exceptions, but this is ongoing. If she'd like to bring somebody in next time that can back her story that there is no construction going on, that'd be great. Same thing with parking. Parking's an issue. Rainwater's an issue. Saying that, most families have 2 to 3 cars. Well, there's 2 to 3 cars for these multifamily units. Most of the neighbors I know have 2 cars at the most. That's pretty much it. I agree with my neighbors on this. I'm worried about rainwater runoff. We've seen construction of the curbs as recently as this year, even though she says no construction's been going on. Safety is also a concern. I worry about maybe my definition of construction is skewed. Maybe you need a permit for it to be called construction. If you just have handymans there every day, it's not construction. I consider that construction. I do worry about safety, having a kid and another new kid coming, having just strangers on the block 6 days a week that are there doing construction is what it looks like, coming in and out of the properties, paints, hammers, this, that, no permits being shown. She doesn't need permits for certain work. I understand that. But I don't know who these people are on a daily basis. They're different every time. I can't get straight out answers, who's with the county, who's not with the county. It just seems a little bit dangerous. I'm a little concerned about that as well. So, thank you.
Any further witnesses? I think that's it. Deliberation?
Well, Madam Chair, I guess my concern is that, not with what the neighbors have said, but I think maybe one did say there were conditions placed on the initial construction of those decks, and that they not be enclosed. That's kind of a problem for me. I don't see it as living space. I see it as more. I don't see it as bedrooms. I see it as more living space. But the basic problem is that they're decks, and they're not to be, a year later enclosed. That's the basic problem. And I don't see, the concerns of the neighbors. I understand after having heard many, many cases. The neighbors do get concerned with things that are outside of the purview of this board. Much of what they said was, but my basic problem is with enclosing that which you historically have been told you can't.
It's fresh.
You allowed your work in the community, trying to bring revenue into the community and make for affordable housing that sometimes rubs neighbors the wrong way. But you're to be credited for trying to make the neighborhood better, at least in your point of view.
Mr. Smith, may I comment on something?
I think not. We're just deliberating.
All right, sounds good.
Ms. Freshman?
You want a motion? Oh, or you want to comment?
Or whichever.
I'll be happy to make a motion, but I do agree with Mr. Smith about the enclosing something that's previously been said not to. But it is also the overall question about non-conforming uses and legitimizing them, if you will, and expanding them, that I'm not comfortable with. And I appreciate the concerns of the neighbors, and I agree that many of the issues really aren't things that we can do anything about. But we certainly can try to stick to the, the ordinances when it comes to non-conforming uses. So I'm prepared to make a motion.
Mr. Russell, do you have any thoughts before then?
No, I agree with what I've heard. This is an expansion of a non-conforming use that seems to me to be unnecessary and throws it into another arena as well.
Okay, Ms. Freshman.
I move the Board of Zoning Appeals adopt the attached resolution denying use permit V-10888-14-UP4.
Second.
It's been moved by Ms. Freshman, seconded by Mr. Smith. All in favor?
Aye.
The motion carries unanimously.
Okay, the next case is related. It's V-10889-14-UP-4. It's a use permit request by Len Capusta to permit a setback of 5.7 feet to the eave, 6 feet to the chimney, and 6.9 feet to the wall of the existing building, and 8.4 feet to the new two-story addition from the left side property line instead of 12 feet as required. Also 10.2 feet to the eave and 11.2 feet to the wall of the existing building from the 21st Road North right-of-way instead of 25 feet as required. This is for a new two-story rear addition on an existing non-conforming two-family dwelling. This is in the R5 zoning district on a premises known as 4137 21st Road North.
And the recommendation is to adopt the attached resolution denying the subject use permit. Again, an alternative resolution has been provided should the BZA wish to approve the use permit. Start, Ms. Capusta, do you have anything else you want to say? Zay, did you want to add anything to what you had said before?
I was going to say they were not intended to be closed, but that was our last resort. That's why.
So, well, actually, come to the podium, and yes, you may say something.
So yeah, we've been waiting a year to try to find a solution, an adequate solution. I have not rented these apartments due to that, and so we assumed this would be the least possible that we would be allowed to do, being that the structures are already there, and we desperately need living space. And yes, the office is supposed to be, I don't know why they didn't write it, but it is supposed to be a bedroom. That's why there's a sitting room here and a closet. Obviously, you can't have a bedroom inside of this small on the second floor, and that's been our whole problem. So basically what I'm trying to say is we are allowed, from what I understand, to have 4 people. I don't want 4 people. 4 people is just too much in such a small space. All we have A-level is 1 floor and the basement. There's 2 bedrooms, 2 bathrooms in the basement, and I guess it would be 2 bed for 4 and 3, 2 bedrooms, 1 bath on the A-level. The upstairs is the problem in that there's a master bedroom suite, and then there's the smaller bedroom that we're trying to create into the closet. And then only for B, 4137B and 4145B, the office is going to be the bedroom. And that's why we have it open into the sitting room space and the closet. So I'm not trying to hide anything. Only 4137B and 4145B are going to be bedrooms for the office where it says office.
Ms. Okay.
Yeah?
No, I'm sorry, please finish.
Okay. So basically, I have waited so long to try to find a solution to this and to be able to rent. And I don't think it would be so difficult. I know it won't be difficult for us to enclose it, and everything will be done within a month of doing all three of them. We will be done before the end of the year. So I'm really surprised, being that we did do the indentations, or whatever you call it, to be able to be allowed to have the decks, that we wouldn't be allowed to just enclose it to be able to gain this space that we've been desperately seeking for this last year.
Okay.
First we tried, I was told 3-story addition would be allowed, but we would need to go to BZA. So I said, okay, fine. Then I learned better. Then we found out that a loft was possible with just a dormer on the side to be able to have a stairwell. I mean, we have been trying to just find a solution to be able to add just a little bit extra space.
Okay, let me just respond to a couple of points you've made. First, let me ask you a question. Were you unaware that there were conditions on the granting of the deck in the first place, that they not be built over?
Yes, we were, and we were not planning on doing that. In fact,
so I guess my question with that is, you just said you've been looking for a way to enclose them. That seems inconsistent with your understanding that they were only granted with the condition that they not be enclosed.
I'm sorry to interrupt. We've been trying to find a solution to get more space. And I said that because we've already had them indented, I was told while we were waiting for the lofts to be approved, I said, if we don't get approved for that, can we enclose the decks?
But again, my point to you is, you were on notice that you cannot enclose the decks because that was a condition of your getting the deck in the first place.
Okay, but that's why we're here at BZA. So I just assumed.
No, the reason you got the deck in the first place was because you got an exception by the BZA to put the deck on.
Okay.
That exception said specifically that those decks would not be enclosed.
Right.
So your expectation that you can come back and change those rules is what we're struggling with here, and I think what the neighborhood is struggling with a little bit as well. The BZA, whenever you come to the BZA, that means you're doing something that you can't just do.
Right.
So
no,
when
I
somebody
understand.
tells you you have to build a loft, but you can only go to the BZA, that means the ordinance doesn't allow you to do it. And I think your assumption, and what I'm hearing in your statement is, your assumption is you can do it if we'll just you come here and we rubber stamp it. That's not how the process works.
No, and I understand that. And that was our last solution of trying to get space. I mean, there's no other solution to be able to get the space. I don't know if you would just allow us to enclose the upper just to be able to get space.
I think we're saying we're not going to allow you to do that.
Right, and I'm understanding that. But I also wanted to speak to this, that the neighborhood seems to think we're doing construction all the time. We, again, have not done any construction whatsoever to the outside. The decks were it and the sunroom was it. We did driveways, yes, and we're adding to the parking spaces that we have such a problem on the street. So I don't understand why they're saying we always have construction going on. We haven't been there in a week. Last thing was we added more kitchen cabinets. We painted, we drywalled. I mean, I don't understand why they're always saying that we have construction going on. There's construction up the street, there's construction across the street, but yet we're blamed for doing construction in 2013? I don't follow. I really don't. I mean, I'm just clueless as to why we are being blamed for construction when there is no construction. We haven't added anything to the outside.
No,
So
thank
I
you.
just wanted to state that. Thank you.
Madam Chair, if I might,
No.
I was going to make a motion.
Oh, I think we still have speakers. Are you good? Or does anybody have anything else they want to say? Mr. Kovac?
Thank you. There's just one little thing I would like to say. I would like to clarify my position because I have a feeling that perhaps something I said earlier might have been misinterpreted. I bought a house in this neighborhood with great difficulty after many years as a renter. It was very difficult for me to find affordable housing in Arlington when I was a renter this time. I'm very sympathetic to the plight of people who need affordable housing in Arlington. Before anyone can conclude that these units in any way help those who need affordable housing, one would have to know what the rental rate would be. I can assure you that the rental rate on these units is comparable to my mortgage for a significantly larger house. I do not think that this particular construction benefits the neighborhood or anyone else. I would love to see affordable units of housing in our neighborhood that families could move into. That's not what has happened so far. I have no confidence that that's what's going to happen. That's the only thing I wanted to say. Thank you.
Appreciate it. Thank you. Anyone else in the neighborhood who want to speak? Mr. Phillip. Mr. Phillip McGeorge. I know. They have a right to be heard, Ms. Freshman.
Yes, we'll try and stop, arguing with each other about who did what, because the issue is really what's going to be built there. And we're just all in agreement with this Article 16, Section 16.2.5.a, that you stay within these setbacks. And, I just don't know why an exception would be made because you say you need space. You need space for what? Because I want to make more money on rent. Okay. Well, you're not allowed to. You can't go out any further. And like you said, you can come here and ask, but just because you ask for it doesn't mean you get it. And I don't see any good of giving somebody more space and going outside. Where does it supersede what the requirements are by the county? That's what I'd like to know. If she needs more space, maybe the solution is buy a different property or something that's conforming, or I don't know. She's asking for a solution, but we don't have it. We just know what the county lets you do, and they don't let you do certain things, and we're in agreement with that. So thank you for your time.
Thank you, Mr. McGeorge. Everybody else good? Okay, I think we're ready for some a motion.
I would just like to say that this is a solution in search of a problem. As far as I'm concerned, these are rentable units. A search for more space is not our problem any more than enclosing porches is a problem. It's not a problem. And I support not do, I mean.
Madam Chair, I was going to move to adopt the resolution, but I do want to put on the record that individuals who own property have a right to come to apply for variances or for use permits. There's nothing wrong with that whatsoever. I don't ascribe any disparagement towards a landowner who does that. I'd encourage the rest of the citizenry to take the same position. It doesn't make for good neighbors to question why someone is making use of their right to petition the government, which is what they have a perfect right to do. But sometimes they're wrong. And in this case, the petitioner, Ms. Kapusta, is wrong. The rules are clear. We said you can't enlarge what you've done. And so therefore, Madam Chair, I'd move that we adopt the resolution denying use permit V-10889-14-UP4, subject to the conditions that, there are no conditions that we just deny.
It's been moved by Mr. Smith, seconded by Ms. Freshman. All in favor? Aye. Our last case, Mr. Noxon.
Okay, last case tonight is V-10890-14-UP-4. It's also use permit request by Len Kapusta to permit a setback of 6 feet to the chimney, 6.4 feet to the eave, and 7.6 feet to the wall of the existing building. Also 8.9 feet to the new two-story addition from the left side property line instead of 12 feet as required. And finally, 10.4 feet to the eave and 11.5 feet to the existing building from the 21st Road North right-of-way instead of 25 feet as required. It's for the construction of a new two-story rear addition on an existing non-conforming two-family dwelling. It's in the R5 zoning district on a premises known as 4145 21st Road North.
For the record, the applicant and her representative have left the hearing. We still have representatives of the neighborhood who previously spoke against two compatible applications. Any additional testimony from those neighbors necessary? Okay, we'll incorporate your comments from the first two cases into this one. I think we're ready for a motion.
Madam Chair, before making a motion, I do want to make a comment about the staff report. Thank you, Mr. Noxon. And it's important for the neighbors to hear this. The staff found that the proposed change to the existing structure will have neither a positive nor negative effects on the health and safety of the neighborhood. Number two, staff found that the proposed change to the existing structure will barely have any impact on the overall building. If anything, it will give a more appealing look to the property itself, hence the neighborhood at large. This neighborhood is a developing area with many improvements occurring in general, and this proposed change will add on to the entirety of the area development. The proposed, and the staff goes on to say really positive things. The one thing that does prevent me from supporting the applicant's application is, again, the earlier determination when we gave them the right to put the deck on that it can't be enlarged. So, I'm sorry. I thought that there was the staff. I was reading from the statement of justification, but
I was going to say that's not what the staff said.
The staff was not unfavorable in total regard. They, when I read the staff's comments, there were positive comments. I was misreading, but would the proposal promote compatibility of development? They say that it would somewhat promote compatibility with the area of the surrounding property. And then it will not add additional dwelling units. Also, the proposed addition will not add a third-story additional height as previously proposed. That these improvements that they sought were not so heinous that it caused the staff to have an adverse reaction overall. And I just wanted to make that point, even though I misread part of the application, but staff didn't just summarily say no, absolutely not. But I'm willing to move that the Board of Zoning Appeals adopt the attached resolution denying the request and of V-10890-14-UP4.
Been moved by Mr. Smith, seconded by Ms. Freshman, to deny the use permit application. All in favor?
Aye.
Aye.
Motion carries 4-0. Thank you very much for coming this evening and staying through a very long agenda. We have one more order of business for the board, our minutes of October 9th, 2014. Been moved by Mr. Russell, seconded by Mr. Smith. All in favor?
Aye.
Aye.
I abstain, I was absent.
Oh, I was just going to say, no one against and one abstention. The motion carries 3-0, Mr. Noxon.
Move dismissal. I move adjourn.
Ms. Freshman moves to adjourn. Mr. Smith?
Second.
Seconds. Mr. Russell's out the door. All in favor?
Aye.
You guys are just making me really hard, my last meetings.
What do you mean your last meeting? I thought you said you were going to be here next month.
One next month.
Huh?
Yeah.
Okay.
It's going to be just as long next month.
All right. All right.
Just recycling.
And there you've seen it at least 2 o'clock before.
Hey, I've done pretty well.
That wasn't bad. 12:30. I thought it was going to be longer. Maybe it would have been. It might have been, or 12:26.
It wasn't even, I mean, it was so late that wasn't even as contentious as I thought it might be.
Right. Right. Right.
exhausted. This was good. You did a lot. Yeah. I wanted to fight the U.S. Attorney one more time by going away.
Did you actually hear confirmation from Monica? It sounds like that's the case.
I think she was going to, but when I told her I was resigning in November, she got freaked out and thought she might have to stay. So I don't know what she decided, but I think the reality of her life is that I think she needs to step down. So whether it's in December or February, it might be just as easy. I just wish we. Yeah.
To follow up with her tomorrow.
We're leaving. I'm sorry.
I understand that. There's an iPad laying over there, you guys aware of that?
Yeah.
Yes. Double checking, because the building's locked and the stairwell's locked. He gets back up here and he's got a problem.
Yeah, so I